Hey everyone. Today we're going to head on over to Travis County, Texas, and catch up with Alan. Alan likes filing pro se lawsuits. He's actually okay at writing them. He starts with a relatively good argument, but then they seem to nosedive deep into this dark abyss. The backstory on this case blew my mind. I have never seen anything like it in my life. But I'm not going to give it to you all up front. That would mean you missed the good part at the end. So right now, Alan has 8 open lawsuits in Travis County, and they all seem to stem from this one landlord-tenant case. It's an eviction case. So let's go check in with Alan. Oh, and by the way, 2 judges have already recused themselves, so this is a retired judge that was brought in specifically for Alan's cases.
This court is now in session. The Honorable Laura Livingston presiding.
Good morning, everyone. I'm Laura Livingston. I am a retired state district judge in Travis County, and since my retirement, I have agreed to sit by assignment, and on this case have been assigned to this cause number. I want to go through some preliminary information, get introductions, and then we'll begin with our proceedings. First, let me call cause number CV 23005479. Estancia Villas versus, and I'm not sure how to pronounce the last name of the defendant. I understand his first name is Alan. Is it Way? Tell me how to pronounce your last name. You're muted. You're muted, sir.
There we go. Can you hear me now?
Yes. What?
Yeah,
How do you
Alan
pronounce your
Way?
Way? Okay,
Yes,
perfect. That's helpful. Thank you. Okay. Let me make some preliminary comments. I am sitting by assignment, as I mentioned, because I'm a retired district judge. I've been assigned by the presiding judge of the 3rd Judicial Region to this case. Initially, I was told that I was going to be hearing a motion to recuse, and now I understand that the judges in the cases have voluntarily, or all of the county court at law judges for which this is a county court at law case, have voluntarily recused. So it's my understanding that that matter is moot. So that means now I'm going to be assigned to hear the merits of the case. That's my understanding. If that's incorrect, you can offer correction to that in just a minute.
Yeah, that's incorrect. There was a motion to recuse
hold
the judge.
Hold on. I'm going to just kind of set the agenda, and then I'm going to come back to each one of these. So that's the first thing on the agenda that I want to clarify. It's my understanding, and I have been assigned by the court order to hear the merits, and I've been given jurisdiction until the court loses its plenary power. So I'm doing whatever it is that's going to be involved in the case. That's my understanding. And so if you have a different understanding, we can get to that in just a minute. But that's sort of item number 1 on our agenda. Second thing I want to point out is that I received a phone call on my personal cell phone number a few weeks ago. And I don't know who made the phone call because the person on the phone never gave me their name. So I don't exactly know who I spoke to. I just want to disclose and report to everyone involved that I have received a phone call and from a gentleman. We did not discuss the merits of the case because when the gentleman called and started saying he was calling about a cause number and he started saying CV, and we never even got to the whole cause number, I interrupted the caller by saying, "Whoa, stop. I think you may have the wrong number." That led to us, between us, a conversation about, I couldn't understand why somebody might be calling my personal cell phone number. I did some investigation, learned that a mistake was made on the part of the county clerk's office. When the county clerk's office sent out information to the parties, they included information that was meant to go to the county auditor, not to the parties. That information had my cell phone number on it, and so I got a phone call. Whoever it was did not tell me their name, so I don't know if it's y'all or not. I'm assuming it's someone involved in this case, only because they started by saying CV something, and to date, this is the only CV cause number I've been assigned in this year. So putting 2 and 2 together, that's my understanding. But as I said, we did not have a substantive conversation about the merits of the case. because I stopped the caller by saying, you know, we have these ex parte communication rules and you can't talk to the judge without the other side being present, blah, blah, and so forth. And then I've followed up at the clerk's office to find out how in the world my personal cell phone number might have been given out. And they confessed mistake. And so now there's training involved in all of that. So not a problem, I don't think. As I said, we did not discuss anything related to the substance. Those are the two things that I needed to disclose, and so start with you. And then the third thing, of course, on the agenda will be the merits of your lawsuit. And let me tell you what I understand about that so far. There was an eviction in JP court that led to an appeal from the decision from the Justice of the Peace. The appeal filed in county court is what is before the court today. So by way of agenda, those are kind of the really two things on the agenda. The third thing was just my disclosure about the phone call. Now, with all of that having been said, let's begin with introductions. Who is here on behalf of the plaintiff, Estancia Villas?
Good morning, Your Honor. Erin DuBois on behalf of the plaintiff, Estancia Villas, LLC. I also have my client's representative, Ms. Jennifer Alvarado, as well as Amanda Cantu. They're both with the property.
Let me just write those names down. Jennifer Alvarado, and I'm sorry, what was the other one?
Amanda Cantu.
And Ms., is it DuBois, like B-O-Y, but okay.
Yes.
Your counsel for Estancia Villas and Ms. Alvarado and Ms. Cantu are the client representatives, is that correct?
That's correct, Your Honor.
All right, very good. And for the defendant, Mr. Way, you could just state your name for the record, please.
Hey, I'm Alan Way, representing myself pro se in the countersuit as counter plaintiff in this case number.
All right, let me make a note of that.
And I did want to get a little clarification. There was a motion to recluse the judge. He went ahead and signed it. 1 or 2 days after that, there was another judge who additionally signed it, is why the assignment, I guess, was assigned to you. And by the way, I've already spoken to I think it was a 200 or 300, some sort of administration, but the judge who assigned you, I've already spoken to him about the merits of the case too. So I just wanted to go ahead and clarify that. And then I was
sorry, back up. What judge are you talking about there?
Whichever judge assigned you to this case, I've already spoken with him about last week.
I have not spoken to the judge who assigned me to the case, so that's helpful to know. Okay, very good.
And then I just wanted to make a note as far as the reclusal goes. We've already there's multiple motions that have been filed into the case. I don't know if you just want the counsel of appearance for right now, but I'm ready to basically state my claim.
Okay, so the way it'll work today, now that we've kind of dealt with the preliminaries, is that I'll hear opening statements from Ms. DuBois and then from Mr. Way. And do that in that order because Ms. DuBois represents the plaintiff. They're the folks who kind of brought the eviction case in the first place. So I'll hear from them first, and then I'll hear from Mr. Way. But because Mr. Way has a counter petition, what I'll do is ask Ms. DuBois to sort of lay out her client's position, and then I'll ask Mr. Way to lay out his client's position. My thought is that in order to make this the most efficient proceeding, Mr. Boyd, you can anticipate Mr. Way's concerns on his counter petition and just tell me everything related to your side of the case. Mr. Way, in both responding to the plaintiff's claims, but also advancing your own claims, go ahead and just tell me everything you want to tell me about your side of the case. Instead of going, 1, 2, 3, 4, back and forth, just do everything they want to say, everything you want to say, and then, we'll hear evidence after the opening statements are over. And then we'll hear after the evidence phase is finished. And I've considered all the evidence, if that's live testimony, any witnesses you may want to call, any documents that might be admitted into the case. Once we've heard all the evidence, then I will hear closing arguments. And again, we'll just do that from the plaintiff, the defendant, and then because of the way the rules are set up in our civil cases, I would hear from the plaintiff, the defendant, and then because the plaintiff is the plaintiff, they also have the right to close. So it'll be Mr. Boyd, Mr. Way, and then Mr. Boyd, and that's it. So that's kind of Sorry?
Yeah, I'm sorry. I just wanted to mention before we go back and forth with the argument, the assignment that you guys are or that you're on right now, specifically, it also mentioned in that order that all of my other cases in Travis County, you're going to be handling at this point in time. Like I literally do not have the option right now to even petition or do anything as far as the cases.
Hang on a second. I'm not aware of that. I'm
It's in your
only
order.
aware. Okay, I hear you. What I'm saying is that I'm not aware of other cases at the moment being set for trial other than this one. So
And-
if I'm to hear some other ones, we
Mhm.
need to get those scheduled for a hearing because today I'm only dealing with this one cause number.
For sure.
I'm happy
And
to
just to specify-
hear.
I
Hang
hear
on a
you.
second. I'm happy to hear other ones, but I don't have those scheduled at the moment. And so
Mhm.
we need to work out you.
One at a
and
time.
Yeah, and if they involve the same parties, then obviously y'all could coordinate and we can, set them on the same day maybe. And just pick one day and kind of knock
Yeah.
them out, if that makes sense to you all. But I'll leave
Yeah.
that to you guys, because I don't know how much time you have available to hear the other cases and so forth. So today, I'm just gonna handle this one, and I would ask you and whoever is on the other side of your other cases to get together with the clerks and with Ms. Burks, Angela Burks, and schedule those other matters. Because right now I don't have anything scheduled except for this one.
Copy that. And just to add a comment to that, this is in fact a hearing because I've had a demand for a jury trial for forever. And that's actually the preliminary reason why Todd Wong, along with his bias, we had a motion to recluse him. This is supposed to be a jury trial. So this is just a hearing.
So let's clarify then what we're doing today, because I understood that this was going to be a trial on the merits.
No. I'm
Mr.
sorry.
Wade, hold on. So let me point out some other sort of preliminary things and procedural things. Miss Duet that you see on the screen there is our court reporter. She's taking down everything we all say.
Perfect.
She takes down what I say. She takes down what everyone else is saying. And in order for her to get a clear record and in order for her to hear what everyone is saying, we must speak one at a time. So things like perfect in the middle of what I'm saying makes it hard for her to follow and write down everything. So if you don't mind, Mr. Wade, just wait until I call on you or call on Mr. Boy or something like that. Now, the one exception to that, of course, is if somebody during the evidence phase has an objection, you do need to say objection. That interruption is perfectly okay and necessary. So please feel free to say objection during the evidence phase of the trial. But during opening statements and closing arguments or just a question and answer phase between the lawyers and the judge, we really need to speak one at a time so she gets to hear everybody so that everybody else can hear everybody and that we're not interrupting and she gets a very clear record for appellate purposes. Okay?
Okay.
All right, good. All right. Now, let me start then with adding to item number 4 on our agenda, which is sort of related to number 3, the merits of the matter and all matters being assigned to me, the jury demand, because
Your Honor,
I understood that we were just hearing the merits today. We're going to hear the merits of the case today, but let's get that clarified. Mr. Boyd, let me start with you. What is it that you think is set on the docket for today?
Your Honor, a trial before the court on the merits of the eviction is set on the docket today, as well as plaintiff's motion under Texas Rule of Civil Procedure 510.9 concerning immediate possession of the property. And Your Honor, to clarify on the jury demand, this case was initially set for January 17 of 2024. The courthouse suffered water damage due to the freeze that previous week. And so that setting had to be removed, and then it was set for February 20th of 2024. The defendant did file a jury demand on, Your Honor, Mr. Wee, I believe, is recording this proceeding.
Is that
Mr.
not okay?
Wade? No, Mr. Wade, you may not. It looks like you.
Didn't you say it was live recorded?
No, it's being streamed live So if you want to look at YouTube, you can. That recording will be taken down when we're
Perfect. Okay, I'm
finished.
sorry. I apologize.
Well, it won't stay up long. So if you want it, you should look at
Just
it quickly. But we're live streaming under the rules because we want to cooperate with the open courts provision of our law. But you can't individually record the session.
I apologize.
Okay, no, don't worry about it. Go ahead.
Your Honor, the defendant filed a jury demand on the 11th of January. The court, Judge Wong in County Court 1, entered an order on January 26th denying the demand for a jury trial of 12 jurors. This is in accordance with the Texas Rules of Civil Procedure 216. The jury demand was not timely. It was not within 30 days of the trial date. And it was also in county court, we have juries of 6. And so the court properly denied Mr. Way's jury demand.
Okay. Well, I'm happy to take up that request today because it is, well, no, that wasn't from the JP order. That was Judge Wong that made that choice.
That's correct, Your Honor. And this was on January 26th
So
of
that's not
22.
really, sorry, that's not really part of the appeal from the JP court. He didn't demand, did y'all have a jury trial in JP court?
No, Your Honor.
Okay. So the jury demand came only after it had been appealed to county court?
And after the case was set and it was not timely.
I see. Okay. And Judge Wong made the decision on the denial of the jury trial because it was not timely and a denial on the when the request was made for 12 versus 6 jurors. Is that right?
I believe that's correct, Your Honor. The order is in the case on January 26th.
Okay. And so if you could just back up a little bit, when was the case heard in JP court?
I believe in November, Your Honor.
All right. And then the appeal was perfected in county court when?
Okay. Are we having fun yet? So while she's searching for dates, let me run you through the background of the case. They go through the history, but it's pretty confusing. And they only scratched the surface, which I'm not getting much deeper than that. There was a lot going on here, and it takes a nosedive pretty fast. So a non-payment of rent case was filed, which we've seen a million times. There was no triable issues, which we've seen a million times. Judgment was entered in favor of the apartment complex. No big deal, happens every day. But on that same day, Alan filed a statement of inability to pay. Now, this is something. Hi, Roxy. Sorry. This is something that's unique to Texas. I've never heard of it anywhere else. They may have versions of it in other states, but it's basically, it allows the defendant to remain in possession of the residence, but it has specific conditions. And it says a defendant who appeals an eviction for non-payment of rent by filing a statement of inability to afford payment of court costs is entitled to stay in possession of the premises during the pendency of the appeal by complying with the following procedures. So he immediately appealed that termination of tenancy, immediately appealed it. But when he appealed it, he put in there that he was unable to pay for the court costs and everything else. So that allowed him to stay in the property, even though he hadn't continued to pay it. The catch is you have to do something special to make that happen. And what you have to do is within 5 days of the date that you file the statement, you must pay into the Justice Court Registry, escrow, an amount set forth in the notice, which usually is 1 month's rent. He did not do that. And that is where this becomes an issue. If he doesn't do that, then the apartment complex can do a couple little things and everything's fine. If he did do that, then he would be back on top and he would be arguing actual issues. Yeah.
Your Honor, I don't, let me see. I'm sorry. So the Justice Court eviction, I believe the judgment was sometime in, could have been October, it was, or early.
That's fine. I'm really just asking more specific. I
Sure.
understand that happened in 2023. I'm really asking, at what point was the case then appealed, perfected in county court?
The case was docketed in the county court on November 28th of 2023.
November 28, 2023. And when was the jury demand came only after the case was set for trial? Or
That's
before the
correct, Your
case
Honor. The case was set for trial on December 22 of 2023, and Mr. Way filed the jury demand on the 11th of January, which would have been 6 days prior to the original trial setting of January 17th.
Okay, all right. Mr. Way, are those dates accurate?
The
You know what I'm
dates sound accurate, but the information is 100% inaccurate. I have time and date stamps because I was filing pro se. So I was able to request a jury demand pro se via email. The same channels that I requested that demand from, I was able to process a subpoena, 4 of them. And 5 of them, the 5th one actually got delivered. It took 4 attempts. I'm just basically specifying that the same channels that I requested that demand from, I was able to get the subpoenas, and that's Travis County. What is it?
Right, but I'm asking a slightly different question. I'm asking about the dates, because it's the dates that will drive. I'm trying to understand the decision about the denial of the jury demand. And so that I'm looking to see when those things happened.
Oh,
And
for
that's what I'm
sure.
asking. So
I hear you.
So Mr. Boy is telling me that y'all had a hearing in justice court back in 2023, and that the case was then appealed to county court also in the late 2023, and then set for a trial in January of 2024 on January 17. But then she tells me that you filed you didn't have a hearing that day, but that's when it was scheduled. And then she tells me that you filed your jury demand on January 11. And so that's what I'm asking. Are those dates accurate?
Those dates are inaccurate because she's giving you partial information. As
Okay,
far
well,
as
let me hold on. Let me ask you then to tell me just what I'm looking for right now is kind of
the date. I got you.
The bigger picture. And right now, I just want to know
Inaccurate.
what day did you file? What day did you file your demand for a jury? That's my question.
My demand for a jury was filed sometime in December. I think December 21st is when I filed it. But listen, I filed multiple attempts or multiple demands for a jury trial. 3 of them in December, and then they told me they moved in 2024. Since I was pro se filer, they said, look, you're not allowed to file anymore via email. They changed the channels. I had to use e-file. Erin is literally on record saying that the email that she was responding to, which I have time and date stamped, saying that she wasn't served. Travis County stamped the demand for a jury. They stamped it on the 11th. Now listen.
Okay, so wait, hold on. When you say they stamped it on the 11th, are you talking about the 11th of January 2024?
Yes, ma'am. So Travis County says
hold on. Are you telling me that, let me ask you a better question. Do you have a file stamped document in which you requested a jury trial that is filed in the court that has a file stamp on it? Do you have a copy of that document?
Yes, I do.
Can you show it to me, please?
The documents are on file. Listen, so on top of that, not only did I file 20, that one's going to be complicated. I have it. It's going to be complicated to find because it's an email. When this happened, I immediately sent over documents of the email to the court, CC1, CC2, county clerk, Erin, everybody was involved that saw it. I sent images to everybody so they could see it. There is no excuse.
So let me
help him clarify real quick. He sent some emails to the clerk and some other people involved. Then it looks like he might have filed something, but if he did, he just filed with the the word jury demand in the subject line with no attachments or anything else. There was no motion written up. Nothing was done like you were supposed to do it. It's like when he filed the resume of the opposing counsel. Yeah. One step forward, two steps back.
Just clarify. I think what I'm hearing you say is that you emailed documents, including your request for a jury trial to people, but it wasn't actually filed in the court file. Is that correct?
What I'm saying is that the means that they were accepting my documents, answer subpoenas, etc., through the filings, because I'm pro se, it's the same channels. The only reason why you would ask for a e-filed stamped copy is if I e-filed. And the reason why I have to e-file in the first place is because they changed it for pro ses, and everybody now, as of 2024, needs to file e-file. So I went to jail based on the same merits of the case for some nonsense that I have to explain. And then Erin, she can't even provide a notice of the trial prior to the 17th. She does not have that. There is no notice. I went to jail and came out and they started lying and doing a bunch of stuff.
Hold on, we're
So,
moving on.
I'm ready.
Yeah, so stay focused with me on the jury demand. I just want to clarify so I'm clear and so we have a clear record.
Mm-hmm.
You emailed
Yes,
lots of people,
exactly.
including people at the courthouse and opposing
Everybody.
counsel. You emailed documents to folks.
You got it.
But you didn't walk over to the courthouse and file it physically. You didn't electronically file it through the e-file system before January 11, 2024, but you sent it by email to a whole universe of people. Is that right?
Yeah, and I wait my turn.
Okay, no, I that's helpful because now I understand sort of the difference in terms of what you think people actually knew versus what was actually in the court file. And that's super helpful. That's helpful. Okay. All right. So now I understand, Ms. Du Bois, what I'm hearing Mr. Way say is that despite maybe not having been e-filed through the e-filing system in January, before January 2024, that Mr. Way sent you and others an email in which he included a request for a jury trial. Is that correct?
Your Honor, I have nothing from Mr. Way prior to January 11, 2024, requesting a jury. The court's file has emails, other subpoenas, things that were filed in the case in January of 2023. Nothing in my file or the court's file, and I'm looking online at the Odyssey Registry of Actions and the documents. I have not seen any jury demand, but for the demand that was sent on January 11, 2024.
Okay, well, he's already told us that there wasn't one filed before then, other than things he may have emailed, which is different.
But Your Honor, there are filings.
You're saying you never received one before then.
That's correct. And there are filings from Mr. Way prior to January 11. There's several subpoenas that he had mentioned. There's emails. There are things in the court's file prior to that date. And I am not seeing any of those things indicating any jury demand. I did not receive one, and I do not see one in the court's file.
Well, I understand that Judge Wong reviewed all that prior to his decision denying the jury trial that was filed in the court file on the 11th. I just wanted to make sure I understood Mr. Way's position and what he sent and who he sent it to and when he sent it, because all that's helpful and information and important information for me to have just so that I can understand how we got to where we are today. Okay, I think I got it. All right. Mr. Way, I'm going to move on because there is no indication in the jury trial, and I've looked at documents that Ms. Burke sent to me by email that were PDF folders of pleadings and so forth. And as I understand it, there was nothing in the court file, although I appreciate what you're saying is that you sent things to all these people. There's a dispute about what Mr. Boyer received or didn't receive. I don't have to resolve that dispute because I do have to go by what is actually filed in the court file. So I'm not going to overturn, not that I have the authority because that's an appellate point. So I can't really overturn what Judge Wong did with regard to the denial of the jury trial. What I can tell you, however, is that all of that is on the record. all of the court filings are in the record. And so to the extent that you don't like whatever the outcome might be today, if you don't like that, you have the right to appeal that decision, as well as the right to appeal Judge Wong's decision not to grant you a 12-person jury back in January. So you have that as an appellate point, and that's one of the reasons why I wanted to walk through all the steps and stages so that we have a clear record of what happened, what you did, who you sent it to, what everybody says they received or didn't receive, and then we've got the court file so that the appellate court above me can then look at all of that and say, okay, here's what happened, and they can decide whether or not Judge Wong's decision to deny the jury trial was correct or incorrect. He's made that decision, and that's the law of the case at the moment. So I'm not going to stop the proceedings and go find jurors. I'm going to proceed to the merits, but understand, Mr. Way, that you do have that opportunity to complain about that at the appellate level.
For sure, for
and
sure,
that,
for sure.
that record would be in here. Does that make sense? Okay.
I hear what you're saying. Carry on. I just want to say that on number 4, the merits of the case would circumvent your decision. So I can't speak right now. I'm gonna let Erin just continue and just say whatever she's got to say. And when it's my turn, you guys please give me the same respect. But I'm ready to go.
Okay. All right. So we'll proceed. January 2024. I'm just making my own notes about that, what we're doing so far. All right. So I think we've done everything on our agenda for the moment, except get to the merits of the case. And as I said, the way that will work is as follows. Ms. DeVoy will go first with her very brief opening statement. And both Mr. Way and Ms. DeVoy will have just a very few minutes to kind of outline, not put on all your evidence, just what's the case about? I understand it's an eviction, so we don't need to spend a lot of time explaining that. But what is the decision that I have to make? That's what I'm looking for in the opening statement. 1 or 2 minutes max on opening statements for both of you. 1 or 2 minutes on opening statement. Now, then we're going to proceed to the evidence phase, and then Ms. Way will call her witnesses and put on her evidence. Then, Ms. DeVoy, sorry. Then Mr. Way will call his witnesses and put on his evidence, and then we'll hear a little bit longer time for closing argument. Because you get to argue, you'll have more time to do that. But opening statement, couple minutes on what does the plaintiff want, what does the defendant want, what does the counter plaintiff want. Mr. Way has both the role of the defendant, but also the role as the counter plaintiff. And then Ms. DeVoy, you have the role as the plaintiff and also the counter defendant. So what does everybody want at the end of the day? What is the ruling you want the judge to make? That's really the point of these 1 or 2 minute opening statements. Ms. DeVoy, you may proceed first.
Judge, real quick. So I just need 1 second. I need to plug in my computer. I didn't realize I didn't have it plugged in. So I need 1 second.
All right.
Let's make sure we have everything on the record, please.
Please don't talk. Wait.
Yeah, so when you say things like that, she can't take it down. So hold on a minute until she's ready, and then she can take it down.
All right, I'm ready. Thank you.
All right, Ms. DeVoy, your opening statement.
Before we proceed on the actual merits of the eviction suit, I would like to present plaintiff's motion, Estancia Villas LLC's motion for immediate possession under Rule 510.9C. We did file the notice of rent default and request on January 9 of 2024.
All right, for everyone's benefit, if you could please just explain
Of course, Your Honor.
the consequence of your request so that Mr. Way understands exactly what you're asking and how it relates to what we're doing today.
Of course, Your Honor. So as the court is aware, this is an eviction. It was appealed from the Justice of the Peace Precinct 3 here in Travis County. Judge Holmes in JP Court entered judgment on November 16. The defendant, Mr. Way, appealed that judgment by filing a statement of inability to pay under Rule 510.9C of the Texas Rules of Civil Procedure. However, that rule, 510.9C 5B1, does require that the defendant, within 5 days of filing that statement of inability to pay, deposit 1 month's worth of rent into the court's registry, that being the Justice Court's registry, And if they fail to do that, then the plaintiff is entitled to request a writ of possession. Mr. Wade did not make a payment into the Justice Court registry. However, the writ request in JP Court was not issued for reasons unknown. On November 28, after the Justice Court case was docketed in the county court, Mr. Wade had continued responsibilities to pay rent as it becomes due into the county court's registry. That's under Rule 510.9C 5B2. Mr. Wade did not make a rent payment into the county court's registry by December 6th of 2023, which is required under the rules, as well as the Texas Property Code. Mr. Wade also failed to pay any rent into the county court's registry for the month of January, which would have been due January 6th. In addition, no rent has been paid into the county court's registry for the month of February 2024. Again, an amount of $1,356, which is the monthly rent, would have been due at the Justice Court level, as well as the county court level on January 2020, in January 2023, would have been due January of 2024, February of 2024, as well as December of 2023. No payments have been made. Therefore, the plaintiff in this case is entitled to an immediate writ of possession under Texas Rule of Civil Procedure 510.9C.
All right. Mr. Wade, let me first ask just a factual question, and then I'm going to let you respond to her request. The factual question, again, this is just a yes or no question. Have you made a payment into the court registry, either the Justice Court or the county court, of any money whatsoever? In what amount? And if so, in what amount did you make it? So
Not
first,
to the Justice Court, not to the county court.
okay, so
No.
you've made no payments.
$0, $0 and 0 cents.
Okay, all right. Now, if you would like to respond to her request, this is your opportunity to respond only to her request for immediate possession only. Just that part of it.
So
Go ahead.
they draft a petition. On the petition, literally they say that they have the exact amount that they claimed in rent. And I have a document. It's time and date stamped. They went there and they said that, hey, I have the exact amount claimed. They next proceeded to attempt to evict me for right of possession only while having all the rent. So literally the moment that they evicted me and passed the petition, they had already
Your Honor, I'm
collected
going to object to Mr. Wade's testimony right now. This is not the merits of the actual eviction.
So
If he
he's
has to respond.
Let me stop you.
Yeah,
Let me
you
stop
can
there.
calm down right quick.
Stop.
Ma'am.
Stop. I got this, Mr. Y. I got it. I don't take what he's telling me as is testimony. He's not under oath. I've not sworn him in. He's not giving me testimony, and because he's representing himself, he gets to make argument in response to your request. But let's be clear, what he's telling me is not evidence, will not be considered as evidence, because he's not yet been sworn in. He's not giving me testimony under oath. So now, I'll overrule that objection then, Mr. Boy. However, Mr. Wade, let me ask you to focus, because I'm only asking you to respond very briefly to her request. I'm assuming you want me to deny her request. Let's start there, correct?
Yes.
All right. And my question really is more in the nature of a response to her legal argument. What
Exactly.
she's saying,
30 seconds.
yeah, just to be clear, what she's saying is, under the law, she's entitled to this, her client is entitled to this writ of immediate possession because you have not, under the law, paid into the registry of the court your monthly rent as it became due in the court. So she's saying you didn't pay it in December, you didn't pay it in January, and you haven't paid it in February. And because you failed to make those payments into the registry of the court, she says she's entitled on behalf of her client to the writ of immediate possession. My question is, since you've told me you've not made any payments, my question is, why is her legal argument incorrect?
Perfect. 4 points. Original petition. 1, they had already claimed all the rent at the time they filed the petition. It's a document that I'll show you in the exhibit later. The next thing is they're not suing for any attorney fees or applicable attorney fees. The third thing is they're not suing for any unpaid rent. The last thing is they were only suing for right of possession. I only appealed the decision because they didn't have any merits to evict me in the first place. Now, let me get to my next point. The fact that they were only suing for right of possession, and I confirmed this with the judge, and literally there's 2 documents where they try to change it up last second. I wasn't required to pay anything because my statement of inability to pay was substituted for whatever document in conjunction with them not requesting any money for rent. So the fact that they only asked for right of possession, and you can confirm this with the JP court, and I also have documentation I'll show you later. That's the reason why I'm not entitled to pay any rent while we're debating and civil litigating right now.
All right, thank you. Ms. Du Bois, your response to his, or your reply rather to his response.
Your Honor, my client is seeking possession of the property as well as back due rent in this case. He filed an appeal on a statement of inability to pay rent. There's been no payments into the registries of the court. The rules require that the court issue an order entitling my client to possession and immediate possession. So this is a non-payment of rent case, Your Honor. My client is seeking possession of the property as well as rent. Mr. Way, by filing that statement of inability to pay, had a continued duty to pay rent to the court's registry and failed to do so. So my client is entitled to a writ of possession.
All right, thank you both. I'm going to hold my decision on this issue until I've heard the rest of the case. So I'm not going to make a ruling on it at this time. I want to hear the rest of the argument and see what the evidence shows, and then I will make a decision on the request related to the immediate writ of possession. I'll save what I think about that until that time. So let's move on. I'll carry this forward as we continue the hearing on the merits and move to opening statements. Again, 1 or 2 minutes just on what it is your request for relief is, because I already understand the nature of the case is an eviction. I understand there are issues related to both rent and possession, and I understand more now than I would normally have in an opening statement. So very briefly, please give me your opening statements, beginning with Ms. Du Bois.
Yes, Your Honor. Again, this is an eviction based on non-payment of rent. My client, Estancia Villas LLC, is seeking possession of the property located here in Austin, 78748, and that's apartment 625. My client is seeking an award of back due rent here today, and the evidence will show that Mr. Way has failed to pay rent beginning September of 2023. The evidence is going to show that my client has a superior right to possession of the property, and that they are entitled to their reasonable and necessary attorney's fees here today. That judgment for the back due rent owed through February of 2024 and their costs of court.
All right. Thank you. Very briefly, Mr. Way, your response just to the, not your response rather, but your own opening statement, both in connection with your defense of the claims against you as well as your counter petition against them. But very briefly, just a couple of minutes on opening. What I'm listening for is, what do you want the court to order at the end of the day?
I just want to take 5 seconds to point out Aaron's body language.
No, you don't get to do that. No, you don't get to do that. You get to give me your opening statement. You don't get to comment on appearance.
I can do the opening
Excuse
statement.
me. Yeah. We don't make personal attacks on people. I'm not gonna let anybody do that to you, and I'm not gonna let you do that to anybody else. So no comments on anybody's personal appearance or anything else. Just your opening statement, very briefly.
Yes, ma'am. So I was evicted on November 1st. They had filed a petition. There's multiple documents on file, but basically, again, let me reiterate those 4 points. They had sued me, and on November 1st, I was up to date on rent, and I can show you the document. They're not suing me they literally have the document signed as an authorized agent saying that they had claimed rent. I wasn't violating the lease. They weren't suing for any unpaid attorney fees or unpaid rent. And then on top of that, basically what I'm trying to get at is the merits at the JP level didn't have any merits. There was no cause to evict me in the first place. The only reason why I appealed was because they sued me for right of possession and won that. But I'm actively suing 6 departments right now because how they've been handling the cases. Currently, there is some very nasty stuff going on in Estancia Villas. Like right now, they've already updated all the smart locks. They've been monitoring me. The authorized representative.
Mr. Way, hold on. Let me break this down a little more basically. I understand that for the reasons you've already articulated, you want me to deny their request, correct?
For right of possession, absolutely.
All right. Now, secondly, you have a claim against them. My question is two questions. First question is, what is the claim? That is, what is the cause of action you're suing them for? And second question, what is the relief that you want? Like, what do you want me to do about it?
I apologize. Here it goes.
Before we dig into that, let's take a quick look at Alan. Who is he? I assumed by as aggressive as he is attacking this hearing that he had some form of connection to the legal field. Nope. None. Nada. Zip. Zero. Zilch. After receiving his GED, Alan joined Job Corps. Now, I've heard the term Job Corps before, but I really had no idea what it was. So I took a minute to actually learn. And it's not exactly what I thought it was. It's essentially a fully funded, income-based admission trade school where students get a college-type experience, living on campus, etc., all that good stuff, but they're taught a trade instead of academics. It's actually pretty cool. So students are housed and fed and all of that, and they're even given a living allowance while in the program. And then they help you find a job with that trade or skill that you learned. Obviously, Alan learned to be an electrician, and he has worked as an electrician since then. I mean, I'm assuming, since he's an electrician, according to his resume. He's had 5 different jobs since November of 2020. So it appears that he's currently unemployed, although his resume states he's a free agent operations manager. It's a good one. He also attended a community college for business in Minnesota at some point, either before or after Job Corps. The Job Corps was located in North Dakota. And so while he was living in North Dakota, it was around like 2015 or so, his driver's license has been suspended. I'm not sure what. I can't find the record, so I'm thinking it was probably something sealed in a juvenile record. And he was pulled over and arrested for driving without a license. This was on the 5th of November, 2015. He was released from jail on the 9th, 5th, 6th, 7th, 4 days. So he spent a couple days in jail. Then, less than 2 weeks later, he's driving again. As he was cruising around town, he passed an officer and decided to flip him off, because that's always a good idea. So the officer runs his plate, sees the car is registered to him, and he's got a suspended license. So the officer tries to pull him over. Of course, he doesn't stop. He leads him on like a short little high-speed chase, going through a construction area, down a closed road, before finally ending up in the parking lot of like a quick lube type place. And he's incredibly combative with the officer, is fighting him to the point that a good Samaritan has to come over and help the officer put him in handcuffs. He's hurling threats and everything else throughout the whole ordeal. They end up calling several more officers to the scene to help assist. They get him in the back of the police car, and he ends up breaking the camera, kicking the partition between the front and the back of the car, and then banging his head against it. It was a little out of control. Way was ultimately charged with reckless endangerment, fleeing or eluding, terrorizing, preventing arrest or discharge of other duties, simple assault on a police officer, and driving under suspension. His bond was set at $50,000 cash or corporate surety. Ultimately, charges 1, 5, and 6 were dismissed, and Way pled guilty to 2, 3, and 4. He had already served 69 days in jail, and the remainder of his sentence was suspended, and he was sentenced to 2 years probation. This was January of 2016. He was arrested again for driving without a license in 2017, and his probation ended up getting extended until October of 2020. I believe he moved to Texas not long after this because there's an eviction on his record in Bayer? The X is silent, right? Bexar, Bexar, Bexar County. I don't ever want to live there. I could never say it. In 2021. In his complaint, Allen starts off by saying, I had amassed some infamy before moving to the apartment complex. And I'm not sure if he means this incident, going to jail, or if he's talking about the music production career that he was starting to have, according to his Facebook page. I can't find any other mention of him anywhere else that would lead up to infamy. I'm not sure. Much of what Allen says makes sense. There was new owners who came in. They set up a new payment portal, and then they were unable to receive payments for the first 2 or 3 weeks. So when they served him the notice to vacate, he wasn't even 30 days late, but I imagine he had made such an impression on them in that short period of time that they were stretching things. You know, like I said, nosedive, way down, down, down. I think he needs to be evaluated by someone with more letters behind their name than me, for sure. Wait, if you're a doctor, how many letters do you have letters behind your name? Doctor goes in front. MD. That's not more letters than me. Anyways, in his counter petition, Allen sums it up initially. He says he believes the director and the management of the apartment complex are running a SEX network, a registry of sorts, and that the director is a government agent who's been monitoring him from inside his apartment and outside his apartment. Part of the paranoia comes from the new owners. When they came in, they kind of upgraded things. They put in new lights, new cameras, security cameras outside the buildings. They put smart locks on the doors, things that technology. I mean, it makes sense. I would much rather have a smart lock with a list of codes than carrying around a whole bunch of keys. But Allen believes they are releasing sensitive data from inside his apartment. They're recording him and they're releasing that to everybody else. And he has quite a list of violations, which he's about to go through with the judge. And then I'll tell you the craziest part. And this is a little slow while he goes through it all, but hang in there because you haven't heard the craziest thing yet.
Criminal conspiracy, child grooming, unlawful use of criminal instrument or mechanical security
But
device.
slow down. I need you to slow down. Slow down. Miss Duet is taking it down in shorthand, but I'm taking it down in longhand. So
I'm sorry.
down. I got criminal conspiracy. Okay.
Unlawful use of a criminal instrument or mechanical security device.
Okay, go ahead.
Unlawful interception, use, or disclosure of wire, oral, or electronic communications.
Okay.
Unlawful access to storage communications.
Okay. All right. All right. All right. Anything else?
Yes, invasive visual recording.
Okay. Anything else?
Yes, unlawful disclosure or promotion of intimate visual material.
All right. All right.
Unlawful electronic transmission of explicit visual material.
Okay. Okay.
Theft.
Okay.
Deceptive business practices.
What else?
Fraudulent destruction, removal, or concealment of writing.
Okay.
Exploitation of a child, elderly individual, or disabled individual.
All right. What else?
Breach of computer security.
Okay.
Electronic access interface.
Say it again, electronic.
Yep, PC 33.022, electronic
just didn't-
access interface.
Interface.
Yes,
Thank you. Anything else?
yep. Electronic data tempering.
Okay.
Unlawful decryption.
Okay.
Improper influence.
Okay.
Witness tampering, tampering with the witness. Probably the same difference.
Okay. Go ahead.
Failure to stop or report assault of a child.
Okay.
Abuse of the official capacity.
Okay.
Official oppression.
I'm ready.
Misuse of official information.
Okay.
Harassment.
All right.
Stalking.
Okay. What else?
And there's another one is a 71.02. It's a RICO charge. Racketeering to influence organized corrupt organizations. I said that correct.
All right. And so is that all of the causes of action that you brought against them in your countersuit?
That's my countersuit right there.
And what are the damages? What is the ultimate ruling that you want from the court? And what are you seeking in connection with those causes of action?
My proposed order of judgment is 200 million and criminal charges be pressed. It's the motion is why there's a motion to escalate to a criminal court. Because this is not civil.
Slow down. Let's do damages first. You're requesting $200 million.
200 million. Let me get back to your screen so I can see you. Sorry.
I just want to make sure I understood the number correctly.
Yes, ma'am.
Okay. And anything else that you're seeking in terms of the relief you seek today? You said $200 million in damages, and there was something else.
Yes, criminal charges be prosecuted against the individuals that were involved as accomplices.
Sorry. Let me just be clear. I want to clarify. You're asking me to order that some prosecutor charge them with these things? Is that what you're saying?
Well, initially it was a motion to escalate, seeing as how there's criminal charges, we need to go to district. But if you what you're talking about,
asking you what you want me to do. What do you want me to order? That's what I'm getting at. You want me to order $200 million be paid to you, and you want me to order somebody to do something related to criminal charges. I'm just trying to clarify what that something and somebody is. Or might be.
I want criminal charges pressed against all of the representatives in estancia villas as far as management goes.
Okay.
All of them that were involved.
So that's what I'm clarifying. You want me to order the DA to go prosecute them in criminal court?
Yes, and investigate estancia villas. I want an investigation open.
Trying to clarify what you want me to do. Anything
I
else
can
you want me
reiterate.
to? No, I don't want you to repeat. I want you to just tell me if there's anything else. I understand you want me to do two things. Well, really three things. One, you want me to deny their request against you. Two, you want $200 million in damages for these causes of action you have spelled out. And three,
Yes.
you want me to order the DA to investigate them and file criminal charges against them.
Got it. That's
All
it.
right. Is there anything else that you're seeking today?
Not for the proposed order of judgment. Deny them, 200 million, investigation, criminal charges pressed.
That's helpful. Thank you very much. And thanks for your opening statements. Let's move on to the evidence phase of our proceedings. Ms. DuBois, you may proceed first with your first witness.
Thank you, Your Honor. I do want to bring to the court's attention Texas Rules of Civil Procedure 510.3E. There are no counterclaims in eviction suits. Those are specifically barred for a number of reasons. Outside of that, Your Honor, I don't think the court has jurisdiction to hear Mr. Way's counterclaims.
All right. I'm aware. I
Okay.
want Mr. Way to have his day in court. I want him
Understand,
to
Your
get
Honor.
out everything that he wants, and I want to understand what he's asking for. And so, like with your earlier argument on the writ of possession, I'm going to hold on to your request in connection with his counterclaims until we get to the end of the proceeding, when I feel like I have heard everybody, that everybody's been heard, that everybody's position has been understood and respected. And then at the end of the day, I'll make some decision after I sort it all out. But I can't really do that until I've heard from everybody. I want to hear from everybody. I want everybody to have an opportunity to tell me their story, tell me what they're complaining about, tell me what the other side's, what their response is to the other side's complaints. And I want to know what everybody's got on their minds before I make any decisions. Okay?
Understood, Your Honor.
All right.
Your Honor,
Now, you may call your first witness.
thank you, Your Honor. Plaintiff calls Amanda Cantu.
Ms. Cantu, if you would raise your right hand, please. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Thank you.
And if you could just state your name for the record, please.
Amanda, thank you.
All right, Ms. Cantu, your audio is a little bit hard for us to hear. If you could just get a little closer to the microphone, that would be helpful to me and maybe to the court reporter and to Mr. Way as well. Just get a little closer to that microphone. That'd be helpful. All right, very good. Ms. Du Bois, she stated her name. You may proceed with your questions.
Thank you. Ms. Cantu, where do you work?
Estancia Villas.
And what is your position there at Estancia Villas?
I am the resident services manager too. So an assistant manager.
So you're appearing
Okay,
as
that kind of broke up for me a little bit. I'm so sorry. Can you repeat your answer?
The resident services manager too.
Ms. Cantu, you're appearing as authorized representative of Estancia Villas LLC.
Yes,
Are you familiar with the tenancy of Mr. Alan Wee?
yes,
Does he reside at and that address is in precinct 3 of Travis County, Texas?
yes,
Is Mr. Way's tenancy there at the premises based upon a written lease agreement?
yes.
Ms. Cantu, I have forwarded over to you and provided to the court Plaintiff's Exhibit 1. Your Honor, would you like me to share my screen?
I think that would be helpful so that Mr. Wade knows what exhibit you have marked as 1 and so forth. I don't know if he's reviewed the box folder or not, so it might be helpful just to make sure we're all on the same page of what document you're asking her about. So yes, please do so.
Ms. Cantu, do you see my screen?
Yes,
Okay. Is this a true and correct copy of the lease agreement between Alan Way and the plaintiff in this case?
yes,
And is this agreement signed?
yes.
Has this been amended, modified, or changed in any way, but for my marking of Plaintiff's Exhibit 1 and the highlighting?
No,
Your Honor, we're going to offer Plaintiff's 1.
Mr. Wade, do you have any legal objection to plaintiff's exhibit number 1? I'm asking if there's a legal reason why I can't admit that document into evidence.
No, that's 100% acceptable.
Okay. Plaintiff's exhibit number 1 is admitted.
Ms. Cantu, pursuant to Box C of the lease agreement, what is Mr. Way's monthly rent?
$1,356.
Okay. Did Mr. Way fail to pay rent in violation of paragraph 3 and 3.5 of the lease beginning September 1 of 2023?
Yes,
Has Mr. Way paid any rent to the property for the month of September 2023, October 2023, November 2023, December 2023, or January or February 2024?
no,
Is the failure to pay rent a default of lease under paragraph 23.1A?
yes,
And does the default of lease entitle Estancia Villas to possession of the premises?
yes,
Are you seeking an award here today of back due rent?
yes,
Are you seeking an award of back due rent of $1,356 for each of the months of September 2023 through February 2024 for a total amount of $8,136?
Yes,
Now, pursuant to paragraph 23.5, are you also seeking Estancia Villas reasonable and necessary attorney's fees here today?
yes,
Are you seeking your costs of court and interest at 8.5% on any judgment that would be rendered?
yes,
Okay. Now, Ms. Cantu, moving back up to page 1 of this lease. So Mr. Ways moved into the premises sometime in August of 2023, correct?
yes,
Were you working at the property during that time?
yes, I was.
Okay. And here, as you'll see, the owner on this lease agreement is Steadfast Estancia VDS LLC. Is that right?
Yes,
Did that entity sell the property to the plaintiff, Estancia Villas LLC?
yes,
Okay. Ms. Cantu, I've pulled up what's marked as Plaintiff's Exhibit 2. Do you recognize this document?
yes,
Is this a true and correct copy of the deed showing Estancia Villas LLC's ownership of the property?
yes.
Your Honor, we're going to offer plaintiffs too.
Is there any legal objection, Mr. Way, to the deed?
Nah, yeah, they own it temporarily.
Do you have any objection to the document coming into evidence?
I do not.
All right, it's admitted.
Ms. Cantu, I pulled up what's marked as Plaintiff's Exhibit 3. Do you recognize this document?
Yes, I do.
Is this a true and correct copy of the notice to vacate that was delivered to Mr. Way on September 21 of 2023?
Yes.
And Ms. Cantu, how did you deliver this notice to vacate?
I delivered it. I went to his apartment to deliver it. Typically, I put them inside the door and tape them. He was actually home and his door was cracked open. So I knocked on his door and he came and was on the phone and I hand delivered it to him.
Okay, so you hand delivered it to him at the premises?
Yes.
Okay. Has this document been amended or modified in any way but for my marking of Plaintiff's Exhibit 3?
No.
Your Honor, we offer Plaintiffs 3.
Mr. Way, any legal objection to this document?
Yes.
What is your legal objection to the admission of the document to evidence?
Who is Amanda Cantu?
No, that's not a legal objection to exhibit number 3. The question I'm asking is there a legal reason why the document that's marked as plaintiff's exhibit number 3 can't come into evidence? Does it violate?
Oh, no, yeah, go ahead. Put that in. Yeah, that's all you.
All right, so plaintiff's exhibit number 3 is admitted.
Ms. Cantu, this gave Mr. Way through September 21, 2023 to vacate. Did Mr. Way vacate the premises?
He did not. I believe it was October 2020.
Oh, I'm sorry. You're correct. So this gave him.
I'm sorry. Can you repeat that answer for me?
He was supposed to vacate by October 21 and he did not.
So Ms. Cantu, because he did not vacate the premises, you proceeded with filing an eviction suit. Is that correct?
Yes, correct.
Okay. Ms. Cantu, have you also had other issues with Mr. Way at the property?
Yes, we've had multiple issues with Mr. Way. He has made multiple interruptions to our operations, basically, during business hours. He made multiple just inappropriate accusations and lies about staff members of UDO and Estancia Villas. He's been very harassing to the staff. He's also made other community members feel very uncomfortable. I personally have moved. I've lived was living in the same building as Mr. Way, just downstairs.
Mhm.
And
Thank God.
I have just moved out due to my own safety needs and my son's. I have a child. And I no longer felt it was a safe space for us, which is honestly very sad because I've lived here over 2 years. And for that to be the reason I no longer feel safe here, not alone at home, but also in work, is very upsetting.
Okay.
And I say the same for other members of the staff. None of us feel safe with here.
Okay. Are you aware of an incident that occurred on January 3 of 2024?
So let me interrupt here by saying that unless any of these other allegations are related to the reasons for eviction, I'm going to rule them out of order.
Your Honor, they are. We have pled.
Are they pled in your petition? Because I understood you were asking for non-payment of rent, a judgment, and
Yes, Your Honor.
insurance.
This was originally filed as a non-payment of rent case. However, our supplemental pleading, we have added other defaults of lease concerning Mr. Way's behavior.
As long as they're in your pleadings, because
They
if they're
are,
not
Your
in your
Honor.
pleadings, I don't think it's appropriate for us to entertain them. Okay,
I
go
understand,
ahead.
Your Honor, and I apologize for not being clear in my opening, but yes, we do have other reasons for a default of lease here, and they
All
are
right.
pled.
Okay, go ahead.
Ms. Cantu, do you recall an incident that occurred on January 3 of 2024?
I actually think it was January 5th, but yeah, if you're referring to the arrest, I do.
Okay, and you just mentioned an arrest. Was Mr. Way arrested at the property in January of 2024?
He was.
Okay.
The actual criminal complaint itself has very little information in it. It just says that he intended to harass, intimidate, like boilerplate language, and it was not helpful. But Alan, being a good guy that he is, filed a statement of reflection in which he explains exactly what happened. Mr. Way writes, I am the defendant in case, and he lists his case number, petitioning for a countersuit against the sheriff's office with respect to these events. And that doesn't even make sense. These events had certainly correlated with negative implications for life, such as defamation of character, loss of high-end job. Never knew there was such thing. And insurance and further ramifications. If I could not make it out of jail, such as repossession of vehicle. He has a license now. Damage to credit, emotional and psychological distress, loss of home. This is on the basis of Officer Salo's negligence and the legal system bullying individuals such as myself. You didn't pay your rent, dude. Okay. He goes on to say, allow me to relay the story with perspective. In pursuit of justice regarding, again with case number. Oh wait, no, this is a different case number. He's got so many case numbers. He's probably got to have like a file to carry around with him, like to keep him straight. I'm representing myself pro se. As Travis County Civil Division will have it, I've been able to communicate motions, orders, subpoenas, exhibits, etc. electronically via email system with the Travis County Civil Court. On January 3rd, 2024, I sent over images to the same recipient. Has relevant information under the title exhibit because I am in a multi-million-dollar lawsuit and I myself have been harassed and stalked, etc. The images were sent over only to show the premise and where the influx of attention initiated, and as a basis for all the psychological tactics. As we are in the age of information and with respect to the digital aspect of our lives growing more and more. Huh? Okay. He argues that there was a restraining order to stay away from 200 yards away from someone, but he has never been to their place of work. He also argues that everything was sent in one instance and harassment would constitute repetitive instances. I mean, he has some decent arguments thrown in here or there, but it's so drowned by the gobbledygook. Fourth, there was no attempt to hear my side of the story. The affidavit only says a 26-year-old female clerk saw images of a new black man. I think he means nude black man. And Mr. Way called in to confirm they got the exhibit as confirmation that it was him who sent over the images. Yes, he sent the clerk pictures of his junk to mark as an exhibit and file for the case. I don't even know how to process that. He also goes on to say that there was something shady about baiting him out of his apartment and that the SWAT team was there to arrest him. I'm really not sure exactly what that meant, but he ends it well. After demanding a jury trial with 12 people, after being told multiple times that juries in that circuit, that district, that jurisdiction are only of 6 people. He's demanding 12. Allow me to summarize, as I'm an individual using the proper legal channels to pursue entities violating Texas Penal Code, and through the same channels that I've been emailing in unbeknownst to me, I get arrested on an expedient warrant by the SWAT team on the premise of a 26-year-old individual being offended by her job, only to yield a 20-year veteran homicide detective to file an affidavit with absolutely no cause and yield a physical restraining order against me as an attempt to intimidate me from using the court systems approved by a magistrate who was potentially have used discrimination on the basis of physical characteristics, only to yield me losing a $160,000 job that was going to establish credibility in said case, period. I think that was the first period of that paragraph. Also losing the ability to answer and petition regarding other case numbers as I would have been in jail, which would have further yet you do more damage in my life regarding me losing vehicle and being homeless, to say the very least. Still don't know what his boy bits have to do with all this jazz? I know. Just wait. He'll explain.
Ms. Cantu, do you see my screen here?
Yes,
I've pulled up what's marked as Plaintiff's Exhibit 4. Do you recognize this document?
yes,
Is this a true and correct copy of an affidavit for arrest against the defendant, Mr. Way, concerning a harassment charge here in Travis County?
yes,
Okay. Your Honor, we're going to ask that the court admit the affidavit for arrest into evidence.
Mr. Way, is there a legal reason why I can't accept this one?
Yeah, it's an ongoing case. It's an active case.
So that's not a legal objection to the document itself. I take your
Perfect.
point. I take your
Perfect.
point. I take your point that it may not be, shouldn't maybe give it a whole lot of weight, but I think your objection, to the extent that you're making one, is to the weight that I give that document, not to whether or not it's actually admissible. So I will overrule your objection, admit the document, but I will give it only the weight that I think it deserves. For petitioners or plaintiff's exhibit number 4 is admitted.
So, Ms. Cantu, is there other bases for terminating Mr. Way's tenancy other than the non-payment of rent?
just other violations of his lease contract, disturbing the comfort of others, disturbing the comfort of the business, criminal conduct.
Okay. And so what you're referencing here, and I pulled up Plaintiff's Exhibit 1 again, is paragraph 11.1 of the lease agreement.
Yes,
Okay. And you'll see here 11.1 specifically prohibits tenants from engaging in criminal conduct. Is that correct?
yes,
Okay. Now, pursuant to paragraph 23.1B is a default of lease for a tenant to engage in a violation of the lease and or a violation of any criminal laws.
yes,
So this is another basis for the property seeking possession of the property, correct?
yes.
Okay. Ms. Cantu, I pulled up what's marked as Plaintiff's Exhibit 5. Do you recognize this document?
Yes, I do.
Is this a true and correct copy of the resident charges and payments ledger for Mr. Way there at Estancia Villas?
Yes,
Okay. And does this document indicate that no payments have been made on Mr. Way's account beginning September 1 of 2023?
yes.
Okay.
No payments have been.
Okay. how much has Mr. Way actually deposited or paid to the property since he moved into the premises?
Let me just clarify before you answer that question, ma'am. If you know the answer from your memory without reference to this document, you can answer it. But since the document has not yet been admitted, I don't want you to testify from the document. You can offer it at this time if you wish, but
Your
one
Honor,
or the other.
we offer Plaintiff's Exhibit 5.
Is there any objection, legal objection to this document, Mr. Way?
Yes.
What is your legal objection?
My legal objection is it's inaccurate.
That's not a legal objection. That really, again,
Okay.
goes to the way you can cross-examine her on it and point out any inaccuracies, but that wouldn't prevent it from coming in. That might,
Absolutely.
does that make sense? Okay.
It sure does.
All right. Then that objection's overruled. Plaintiff's Exhibit number 5 is admitted, but I'll just point out that Mr. Way has an opportunity to cross-examine and offer his own evidence in connection with this document. Go ahead.
Ms. Cantu, how much has Mr. Way paid the property?
I believe it's 720, but also a deposit, or 720.
I'm sorry, I didn't understand. Your audio broke up for me. Could you repeat your answer, please?
$720.
So Ms. Cantu, since the beginning of his tenancy on or about August 23 of 2023, Mr. Way has only paid $720 to the property. Is that correct?
That is correct.
Okay. Ms. Cantu, Mr. Way is still in possession of the property, right?
Yes.
Okay. Ms. Cantu, that's all the questions I have. Your Honor, I pass the witness.
All right, Mr. Way, now is your opportunity to ask Ms. Cantu questions that relate only to the issues in the case.
Yes.
And just as a reminder for us all, just question and answer. So this is not your opportunity to testify. You'll have that opportunity later. Just
Okay.
question and answer.
All right. So why then did you guys write amount claimed as of November 1st to be the exact amount that I needed? Because rent was paid for me.
I'm sorry. I don't understand what you mean by the amount that I needed. So can you
Yes,
just
I
clarify your...
comprehend.
Okay, before he gets us all confused again, he's handling this the same way soft sits do. Picking one detail and honing in on it. The original petition was in a different court and was only for the writ of possession, which was granted. He appealed. He filed the inability to pay with part of his appeal, which would have worked if he had followed through and put the month's rent in court escrow. He misunderstood. And during this misunderstanding, the petition was amended to follow the rules related to that procedure, and as part of that, they asked for all unpaid rent, attorney's fees, etc., because it was getting a little excessive. Think about it. You've got your really expensive attorney having to review every single one of these documents, including a picture of his boy parts. I'm going to post all these documents. There'll be a link in the description for those of you who want to read them all. It might kill a couple brain cells, but have at it.
Go ahead.
Oh, yes, ma'am. So on the original petition, there is an amount claimed as of the date that you filed the petition. Why then is there a balance that doesn't reflect that?
If you're referring to the eviction petition, we will list the amount that is owed at that time of filing the eviction.
You're not understanding my question. And I'll show you the exhibit. The exhibit says the amount claimed as of that time, which you
Mr.
filed
Way.
November 1st. Amanda
Mr. Way?
Cantu. Yes,
Mr.
ma'am.
Way, what you're doing is offering a statement, which is your testimony, right? But we're not at that stage yet. No, you made a statement. You've got to ask her a question. So you could, for example, say, on such and such a day, how much did I owe? And if that's a different number than that's on the document, then your follow-up question could be, well, why is that number different than what's on exhibit 2 or whatever, right?
Okay.
You can
On
break
November
it down
1st.
that way, but you
On
can't
November-
just sort of. Does that
On
make
November
sense?
1st, Amanda Cantu, on November 1st, how much rent did I owe at the time you filed the petition?
On November 1st, your Total balance was $4,426.36. That's including rent, utilities.
Okay, copy that. My next question is, why then would you put the amount of rent claimed as of this date of filing is $4,068.00 on a legal document at 5:30 p.m.
Do you,
11/1.
Your Honor,
I think, let me just make sure I understand the question. I think what I'm asking, Mr. Way, I just want to clarify. The question you're asking is, if you owed $4,400 roughly, why did she only list less than that amount? Is that your question?
Exactly.
You owed more, but she only listed a little less than you actually owed.
And I'm only asking that.
Hang on. No, don't tell me why. Just trying to understand the question. I think what he's asking you, just to clarify, because I was confused a little bit by the question myself. I think what he's asking you is, if he owed more, why'd you put less than what he owed on the documents? I think that's his question. Is that right, sir?
Correct. Yes, ma'am.
That's his question.
at the
If
time
you
of,
owed 4,400, why'd you only put 4,000? That's his question, basically.
yes, at the time of filing the eviction, we are only evicting for past due rent. We are not evicting for past due water, sewer, any additional fees, late fees. It is only for rent, for being in violation of non-payment of rent.
Wow.
So, Mr. Way, you really just have to ask her a question. You don't get to editorialize. Come on.
I'm sorry. I apologize.
That's all right. I know it's not always easy, but if you would, just ask her another question, please.
Why did you put you're not suing for any unpaid rent? Or if you were intending to evict me, why would you put there weren't any lease violations? Why would you put you weren't suing for any unpaid rent or any applicable attorney fees on this original petition? Why then did you do all those in that order?
Your Honor, I'm going to object to the question based on relevance. This is a de novo trial in a county court case.
Excuse me. I will sustain the objection. Mr. Way, they can decide as the plaintiff whether to sue you for everything they can under the sun or for only some of the things they can under the sun. They don't have to justify why they only picked one thing when they could have picked 20 things. So it's not really relevant. It's only relevant as to whether or not what they did file is true and accurate. And do they get to win their case based on what they did file, not what they didn't file. So I'll sustain the objection. Next question.
That is it for my questions regarding that witness, Amanda Cantu. And we'll get to the testimony, we'll talk.
Thank you, Mr. Way. Ms. Du Bois, any redirect?
No, Your Honor.
Thank you, Ms. Cantu. You may turn over the microphone to the next witness. Ms. Du Bois, you may call your next witness.
Your Honor, I would just like to briefly call myself for attorney's fees.
You'll raise your right hand. I'll swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may proceed.
My name is Erin Ann Du Bois. I am an attorney, counselor licensed by the Supreme Court of Texas in November of 2016. I practice with Rogers Law Firm here in Central Texas, and my primary area of practice is representing multifamily housing owners and landlords. I have represented numerous clients in matters that were similar to this matter, and I was asked to represent Estancia Villas LLC in this case. I agreed to do so on an hourly basis. I charge $290 per hour. I've kept detailed records of my time and bill my time in tenths of an hour and tasks performed. In this case, I have discussed the facts of Mr. Way's tenancy with my client's representatives. On several occasions, I have reviewed and analyzed the relevant documents in this case, the ledger, lease, notice to vacate, the deed. I have drafted the supplemental pleading in this case, as well as the notice of rent default. I have reviewed and analyzed the relevant statutory provisions. I have reviewed Mr. Way's multiple filings in this case. I have prepared to conduct this trial and now tried this case. In my opinion, the tasks I have performed have been usual and customary. I'm familiar with the guidelines set forth by the Supreme Court of Texas on behalf of Estancia Villas. Would be an additional sum of $5,000 in attorney's fees. Your Honor, I have provided to the court Plaintiff's Exhibit 6. This has been uploaded onto Box. This is a true and correct copy of my activities export with Rogers Law Firm showing the work that's been done on this case. Prior to trial today, Your Honor, I have spent 8.9 hours of time on the case, and that was for a total sum of $2,417, and we are just asking for additional sums through trial today for that $2,600. And I'd ask that Plaintiff's Exhibit 6 be offered.
Can you share your screen so that Mr. Way has a sense
Sure.
of what you're referring to when you refer to Plaintiff's Exhibit 6, just in case he hasn't seen it in the box folder? This is her activities report related to the work she's performed. Mr. Way, do you have any legal objection to Plaintiff's Exhibit number 6?
Legal objections, let me see. Yeah, I really think that's inadmissible, seeing as the original petition, but if that's not a legal objection, then carry on.
I'll overrule that objection because this is a trial de novo and they get to essentially have a new trial on their claims, and they've included a request for attorney's fees in that claim. So I'll overrule that objection and admit petitioner's Exhibit number 6.
So when did we get to a de novo trial? Well,
When
I'll get
you
to my
appeal-
turn. I'm sorry.
When you appeal from the Justice Court decision,
Mhm.
when you go from JP court to county court,
Mhm.
in county court, you get a new trial. That's
Okay.
the way it works. Evictions, the Justice of the Peace Court has what we call exclusive jurisdiction, which means every eviction has to start in JP court. Can't file it in any other kind of court, has to be filed in JP court.
Mhm.
From JP court, the Justice Court, any appeal for an eviction from that court then goes to the county court at law. And if there's an appeal from the county court at law, that goes to the Third Court of Appeals. If it's in Travis County, goes to the Intermediate Court of Appeals, from there to the Supreme Court. So that's the sequence of review that you get. Start in JP court, then you get to county court. When you go from JP court to county court, it's a new trial. When you go from county court to the next appellate court, you don't get a new trial unless they order one. You just get an appellate review at that stage. So that's the difference. All right. Anything further, Mr. Boy, or do you rest?
Plaintiff rests, Your Honor.
All right, Mr. Way, it's now your opportunity to call any witnesses or offer any documents into evidence, and you may call your first witness at this time.
Yeah, my first witness, I would like to call Jennifer Alvarado.
All right, Ms. Alvarado, if you would get closer to that microphone, please, and raise your right hand, I'll swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
State your name for the record, please.
Jennifer Alvarado.
All right, Mr. Way, you may ask your first question. Go ahead.
The first question I have to ask is, why would you tell me your name was Amanda Cantu? They've been having me under the impression.
Mr. Way, just question, answer. Question, answer. When it's your turn to testify, you can tell me more, but right now, just question and answer.
I apologize.
No worries. Go ahead, Ms. Alvarado.
Your Honor, I'm going to object based on relevance. There's
Well,
no-
it might or might not be relevant given Ms. Cantu's statement that she hand delivered something to him. So it might be relevant. It might not be relevant. I can't tell yet. I will overrule the objection. You may answer the question if you can.
I have never stated my name as Amanda Cantu.
Next question.
No witness.
That's not a question. You have to ask her a question.
No, I was saying that was it for the witnesses.
Oh, you said no witness. Oh, you mean you passed the witness? You okay? I don't think he has any other questions for Ms. Alvarado. Ms. DuBois, do you?
No.
I just got to speak, apparently.
Okay. All right. Thank you, ma'am. You may step down and you all may mute your microphone. Okay, Mr. Way, you may call your next witness.
Okay, that's it for the witnesses. I apologize.
So you don't have any other witnesses that you want to call? Did you want to offer testimony yourself?
Absolutely.
Okay.
Absolutely.
Well, if you'll turn your video camera back on. There you
Oh,
go.
sorry. I didn't know it was on.
That's all right. It just went off for just a second there.
Okay.
If you'll raise your right hand, I'll swear you in.
All right.
Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
State your name for the record, please.
My name is Alan Way, representing myself pro se in this case.
And your last name is spelled W-E-A-H, correct?
Yes, ma'am.
All right, very good. Now, Mr. Way, let me just point out a couple things just as we get started. Because you're representing yourself and you're acting as your own lawyer, it would be a little silly for you to ask yourself a question and then answer it. That really wouldn't make any sense. So because of that, you'll be allowed to testify in what we call the narrative form, meaning you don't have to ask yourself a question and then answer it. You just get to give me the information. Okay. However, couple things to keep in mind. One, if Ms. Du Bois raises an objection, you'll know that because she's going to say objection, right? Or if I interrupt you, I need you to stop your testimony until I can deal with whatever reason I might have interrupted you or whatever reason Ms. Du Bois wants to raise her objection. So at that point, I need you to stop your testimony till we can deal with those interruptions, and then you can be allowed to proceed. Does that make sense?
Absolutely.
All right, one other thing couple other things to remember. One is you tend to talk pretty fast, and
Sure do.
in order to be respectful to our court reporter who's trying to take down a clear record, I'd ask you to slow down a little bit so that she can get everything you're saying onto our record. Okay?
Gotcha.
Last thing is I need you to stay focused only on the issues that are before the court and not on things that I don't have jurisdiction to deal with or can't handle. So right now it's kind of simple what we're doing, but I want you to be able to tell me your story because I know you have a story to tell and I want to hear it, but I want you to do it. I want you to do it slowly enough that we can hear it, and don't forget to let me deal with these objections. The final thing I want to point out is that we've been going a while, and given the pace of everybody's speech pattern, I'm going to have to give Ms. Duet a break here shortly. So probably in about 15 minutes or so, if she can hang on that long. Looks like she can. All right, good. She's telling me she can go another 15 minutes. I'm going to break at about 9:15-ish, and then we'll take about a 10-minute break, and then we'll come back and finish up whatever we haven't finished by then. But I've got to give her a rest at some point since we've been at it for over an hour. Okay. All right, Mr. Way, you may proceed now with your direct examination.
Yeah.
And then following that, Mr. Boyd will have an opportunity to ask you some questions on cross-examination. But for now, we'll start with your direct examination, and you may proceed.
Yeah, I wanted to start with when I moved in. The first thing that happened was I moved in and signed the lease and everything like that. I checked out building 4. Long story short, they ended up moving me to building 6. It's on the clubhouse camera. When I met Amanda, she gave me her card with her name on it, and it said Amanda Cantu. That's documented. I've asked for subpoenas. I've asked for 4 subpoenas in order to get the information in this case, because that's actually relevant now. Because Amanda Cantu said she delivered a notice to vacate, and she hand delivered it to me, which technically was Jennifer Alvarado. If that makes any sense. Okay, so
I understand what you're saying. Keep going.
Yeah. So basically, they evicted me. I had moved into the apartment, I think August 21st. September shows up, UDR, like some sort of billion-dollar corporation, comes in and buys out this place. They upgrade the locks, do a bunch of smart locks. Long story short, I'm on camera right now. Every aspect of my life is on camera. Irrespective of that, you could just look at the original petition. The original petition itself does not give any merit to even have the trial. Because 1, they had all the money at that point in time, signed and date stamped, and then they weren't suing for anything. I hadn't violated the lease or I hadn't done anything. There was 0 cause to even evict me. The only outlet that I would have is to appeal the eviction. To make any sense, if I wanted to stay there, I would have to appeal the eviction. So as of November 1st.
But may I just ask a clarifying question? The testimony in the record so far from the plaintiff is that you were to pay $1,356 per month
Mhm.
And that to date, you've only paid $720. So when you say you didn't owe any money, I'm confused by that. Could you
Oh.
explain to me the dollar amounts? And if you could, we're gonna take a break here in a minute. If you don't mind waiting to enjoy your breakfast or snack or whatever you're
Sorry.
eating, if you could wait and do that until we take our break, that would be
Understood.
really, really helpful to me. So, if you, I need you to clarify, you're saying
Yeah.
you didn't owe them any money. They're saying you never paid even a full month's rent. Could you just help me understand that?
So what's the amount? 1,300 and what? 56?
I believe the testimony in the record is $1,356 per month.
So that's September, October, November, right? Okay, so that 1,356 multiplied by September, October, November equates to $4,068. If you go back to the original petition, this is what I'm trying to argue here. They literally have the document signed by an authorized representative stating the amount of rent claimed as of this date of filing is $4,068.00. Cause there was no merit to evict me because they had rent. They said they claimed it on my behalf. They're not suing for anything. I haven't broken any violations or any lease. It is literally the reason why we're here right now. There's no other option for me if I wanted to keep my location other than to appeal.
Here's what I'm asking though, Mr. Ware, for clarification. They're telling me that you owe $1,356 a month.
Yes.
And that you have only paid $720.
No, incorrect.
Okay, that's what I'm asking you to tell me. So they're saying they're saying you owe $1,356 every month. You owed it in September. You owed it in October. You owed it in November. And they're telling me in all that, they're telling me in all that time, you've only paid $720. So I need you to help me understand the payments that you've made. Can you talk to me about that?
Okay, so on November 1st, at 5:25 p.m., there was $4,068 paid on my behalf to Estancia Villas, period. In addition to that, that's not even accurate because my deposit in conjunction with the August month adds an additional $720. So in reality, it's actually...
So hold on. When you say that a sum of $4,068 was paid on your behalf, can you tell me more about that? Who paid it? Where's the check? Tell me more about the payment and so forth.
The managers paid it for me because they've been monitoring me. They've been putting me on camera. They've been putting me on camera and circulating my information. There's a bunch of nonsense going on here. And that's what the payment was for.
So hang on a second. When you say that the managers paid it for you, tell me more about that. Who paid it? How did they pay it?
Jennifer Alvarado. It doesn't matter. It was electronically paid for me. It was taken care of on my behalf for me. They have it documented here, time and date stamp.
Why would the managers pay your rent for you?
Thank you. Because they have some organization going on here where they're trying to demasculize men. And as soon as I stepped foot in here, ever since then, it's been a whole campaign to separate my genitals from me. It sounds ludicrous, but there's exact information.
Yes, folks, you heard that correctly. We're going to take a minute and let that one sink in. I've heard a lot of conspiracy theories in my life. This tops them all. I don't know where, when, how, why, what. But he believes it. What I do know in this case is that he was randomly emailing the clerk as opposed to e-filing through Odyssey, and he was sending her very random things. Instead of actually preparing a motion or anything of substance, he would send a picture of a business, or he would send the resume or just a statement about things. And his resume. And then he sent the other attorney's resume. And all of that was put into the record. Apparently, he wanted to show that he still retained possession of his parts. I'm honestly not sure what the purpose was, but he emailed a nudie to the clerk of the court, and that's what led to the criminal charges, because you can't do that. This is why we can't have nice things, people. Quit texting out pictures of your junk. Nobody wants to see your junk. Put your junk back where it is. Gosh. Quit taking pictures of your junk. Honestly, my response is the same as yours. WTF, he needs help. But he doesn't. That's the thing. If you look at our system, he's not a danger to himself at this point. He is not a danger to others. He's having some disconnect with reality. It's causing him to believe things that aren't true. But he's not even close to incompetent or unable to participate in his own defense. In fact, he's handling his own defense. Granted, there's all kinds of gobbledygook in there that doesn't need to be in there. And this judge is doing really good at, cutting that out. But he can read the law. He may have misunderstood a few things, but he's got critical thinking skills. And this is totally fine. There is nothing anyone could do about that. He is allowed to believe the 5G cell phone tower, Corona. Oh, I didn't say that. The beer. Yeah, the beer. Whatever craziness he wants to. He can jump on the what's his name's wagon and spin around in circles. It's totally fine and legal. That does not impact his ability to bring a lawsuit or defend himself in a lawsuit until it becomes vexatious, until he is doing it without purpose and he's just frivolously filing lawsuits everywhere. Then it becomes an issue.
But there's there's visual communications, there's a motion of continuance. You guys are treating this trial like it's just some sort of eviction, copy, paste, cut, paste, and that's it. There's so much information in here.
Okay, so hang on.
That's why it was paid. That's why it was paid for me.
Okay, so hold on. So let me just back up because I want to do this in sort of pieces that I can understand and we get a clear record.
For sure.
If I understand what you're telling me that on November 1 at 5:25 in the afternoon on that day, Ms. Alvarado, on behalf of Estancia or on behalf of herself?
Nope, I'm saying prior to that date, right? It doesn't matter if she says she's gonna pay it for me, it doesn't matter. Prior to that date, it was paid. It was paid on my behalf for that reason exclusively. Me being on camera inside my location.
Okay, so let me just
be clear.
Do you know in what way money changed hands from Ms. Alvarado or anybody else on your behalf to pay your rent? Can you tell me more about how that payment was made? Tell me what you know about that other than what somebody may have told you. I don't want you to tell me what they told you so much as I want you to tell me what you know happened, if you do.
Management paid my rent prior to that date. It's on it's a legal document right here.
How do you know they paid your rent?
Because they told me that they would. I've been on camera. Okay. They've been circulating my information on social media, laughing at me, putting me.
Who told you that they paid it? Who told you that?
The manager, Jennifer Alvarado told me that she paid it. The manager.
Okay. So let me just be clear.
Prior to that date right there. It was paid on my behalf.
Okay, let me be clear. Let me be clear. Your testimony today is that on or before November 1st, $4,068, the $4,068 that you owed in rent to that date was paid on your behalf by the manager of Estancia Villas, Ms. Alvarado.
UDR essentially, but through her as an authorized agent. UDR essentially, but through her as an authorized agent.
All right. So they paid your testimony is that Ms. Alvarado on behalf of her employer paid your rent for you.
They wanted me to leave is why they put that number down there. So they paid the rent to have me leave. That's what that was about.
Okay. All right.
And the reason why, and I'm still in the testimony if I'm okay to continue.
Yes, you may continue.
Okay. The reason why that number is down there is because I've been monitored. They've installed smart locks out here and they have access to my codes. On the inside of this door, I have permission, have the ability to lock the door and prevent anybody from coming inside here. When I exit and I go to the outside of the door, It's an electronic code. When I leave, these guys have me on GPS. I come back inside, my stuff's all over the place. They're setting up spy cameras and all kinds of nonsense and circulating my information. Estancia Villas in general. And when I mentioned that thing about them trying to separate my genitals from me, not physically, but they've been doing all kinds of psychological tactics to do so, like messing around. And I have the visual communications. First and foremost, let me go ahead and reiterate that this was supposed to be a jury trial. The fact that you guys are trying to consolidate the trial, they've been doing so many things to just shut me up, put me in jail. I literally started submitting exhibits to the case. As soon as I submitted an exhibit to the case, here comes an interception from Travis County Sheriff's Office and Travis County Civil Division as if I did anything wrong. We're literally in an ongoing dispute and these guys come in and intercept. This is a massive case I was trying to exhibit here. The first thing I gotta say is, just on the merits of the original petition, like they do not have cause to evict me. Like I said, it was paid on my behalf. That's how much they collected. It was the exact amount. And now look, they don't even have a lease violation. They don't have a holdover. They don't have anything for applicable attorney fees. And it's because I know what I know. The reason for the countersuit was because I wanted to relay what I know. You guys were trying to separate it and do all kinds of stuff. The way that they moved about this was absolutely, they shouldn't even process this case. The first thing they should have said was, hey, this dude didn't even do it. What are you trying to evict this dude for? And if I would have co-signed it, then they would have permission, but I didn't. So here we are.
Let me stop you there. Let me stop you there to ask another clarifying question. Since you take the position that your rent has been paid through November, right? All right. So can you tell me what amount of sums have been paid by you for the months December 2023, January 2024, and February 2024? Have you made any rent payments as required under the lease agreement for the months of December 2023, January 2024, or February 2024?
No. And the reason why, if I'm still inside my testimony, is because with them only suing for the right of possession, and this was told to me by the JP courts, I have documentation of my statement of inability to pay. It literally, so I've been able to not pay rent. They didn't sue me for anything. That literally prompted me not, they just took my statement of inability to pay. So essentially, I don't owe anything to the JP court, and I don't owe anything going forward until we come to trial.
Let me stop you there.
And let me find the document. I'm sorry.
My question was simply whether or not you paid rent. Your position is that your rent was paid through November, that someone paid it on your behalf. That's what you told me. And if that's true, then the question is, on December 1, did you pay rent? Did you pay rent to them?
Okay. Well, on December 1, I did not give any money to JP Court.
Okay, hold on. Mr. Way, stop. I'm still trying to get to the sort of clarifying question I'm trying to ask. So if I understand correctly, you think your rent was paid through November. And so I understand that. If that's true, then the next point in time in which you would have owed rent would have been December of 2023. And if I understand your testimony, you did not make a payment of rent in December of 2023. Is that right?
No, I did not. Can I continue with the testimony?
Hang on. I'm trying to clarify what you said about the payments.
Yes, ma'am.
Okay. So you didn't pay in December, you didn't pay in January, you didn't pay in February, correct?
It was paid.
Right?
I had a zero balance in in December, January, February, and anything beyond that, I have a zero balance. So technically, I did pay.
Stop. I'm asking about things you actually did, not your legal theories. That's why I'm trying to back up and clarify. You're giving me your sort of legal theory about why you owed or didn't owe something. That's not my question.
I got you.
I'm asking a very simple, factual question. Did you make a payment of $1,356 to Estancia Villas in December 2023? Yes or no?
I paid $0 to Estancia Villas in December 2023.
Okay.
As far as December?
No. Just getting some facts here. In January 2024, did you make a payment to Estancia Villas in the amount of $1,356? Yes or no?
No.
Okay. And in February 2024, did you make a payment of $1,356 to Estancia Villas? Yes or no?
No.
Okay. Now, next question. The affidavit of inability to pay. That is a document that you filed in the court file, correct?
Yes.
Okay. I just wanted to make sure factually I understood what you were saying. Now you
Mhm.
can continue with your testimony.
Sorry. Yes. So basically, with that statement of inability to pay, they had a cash surety balance of like $277, and this is why I'm actually suing JP3 too, because they had a cash surety of $2,700, which basically I substituted with that statement of inability to pay, and it is co-opt with the fact that they only sued for right of possession, prompted me to only owe $0.00 going forward, confirmed by JP Court, and I have the documents to prove it. So technically, the original petition, I didn't owe any money, and then Estancia Villa accepted it. They co-signed it. They had the opportunity to say no. They accepted it. They signed off on it. I have that too. Now going forward into the new trial here, my stuff was accepted as far as me not being able to pay. So we have the initial petition, irrelevant. Moving forward to the new trial, I'm not paying for December, January, February, or anything beyond because they only sued for right of possession. Here we are in court to argue about the merits of the case. That's why prior to this moment in time, they did not get any money from me between the points of right now and December 1st.
This is really helpful. I think there may be some
Let me find that
misunderstanding.
document. Sorry.
Yeah, I think there may be some misunderstanding of what things mean that are filed. For example, the affidavit of inability to pay does not mean you don't have to pay your rent, for example.
No.
That's not what it means.
That's not what I'm saying.
But I understand. I think I understand a little better about sort of how we got where we are, and this has been really helpful. I'm going to let you go ahead and finish up with your testimony because now I got a better sense. And we'll get a little farther, and then we're going to have to take a break to give the court reporter a rest.
Oh, for sure.
Go ahead.
Yes, ma'am. So, yeah, that statement of inability. And then so on top of that, I essentially countersued because I was then aware of the nonsense that was going. It's so disgusting. And if you guys, or you don't have the power to process that case, it really doesn't matter. These guys are talking about an eviction appeal as though like, this isn't the biggest news. This is very big. So I just want you guys to know, independent of that, like there will be suits. But if we can escalate to a higher,
don't tell me, don't stop. I gotta keep you focused on this case, these merits.
Okay.
It's the same thing I told Mr. Boyd before she told me she had pleadings about other things. Same thing.
Yeah.
Just focus on what we're here about today. You have
Okay,
a right
I guess
to
let me just
file
reiterate
your
everything then. First, on video in the clubhouse, when I first arrived, Amanda Cantu, or who I thought is technically Jennifer Alvarado right now, handed me a card. And on that card, it said Amanda Cantu. From that point when I initially got here till now, or just about a week ago when she told me, oh, I'm actually Jennifer. Like I was under the impression, and I would call too, and can I talk to Jennifer? Then they would transfer her.
Your
I'm
Honor,
telling you,
again, I'm going to object based on relevance. I have no idea how this has anything to do with the claims.
Because of the notice to vacate. Because of the notice to vacate. Who served it to me?
Mr. Way? Mr. Way?
Sorry.
I'm gonna sustain her objection because the notice to vacate, which is in evidence, doesn't really matter who handed it to you. It matters that you received it. So she's correct. And we can move on from there. Go ahead.
And it's also relevant because imagine having
we're not
a
going to argue that. No, stop.
Yeah.
We're going to move on past that. Go ahead.
Okay, 10-4. So they said incorrect names, whatever. I was under that impression. Now back to the original petition. Again, they have the amount. Literally, it says the amount claimed. It
Your
was
Honor,
inaccurate.
I'm going to object. I'm going to object again based on relevance.
Stop.
I'm just trying to summarize.
No, yeah. So I'm going to overrule Ms. Du Bois' objection, but I'm going to ask you not to reiterate because that's really just repetitious.
Okay.
Everybody's been listening all morning, certainly me.
Perfect.
We have a record.
Just
I don't
as long
need
as
you
I'm
to
clear to you guys.
summarize. I don't need you to summarize or reiterate. I need you to tell me something you've not already told me.
Okay. So you've already gotten the portion of me not owing rent because of the
you don't need to summarize. You don't need to summarize.
Okay.
Keep going. If there's anything else, keep going.
I'm just thinking.
No, take your time. I'll tell you what, let's take our break round. That way you can give time. You have some time.
Some juice is flowing, right?
Yeah. Well, organize your thoughts. I was thinking.
Yes, ma'am.
All right. Let's give our court reporter and everybody else a comfort break. It's 9:25 by my watch. Let's take 10 minutes and we'll resume at 9:35.
Judge, it's 11:25, Judge.
Sorry. 11:25, we'll resume at 11:30. I'm looking.
Okay, before I let you see the hot mic break in all its glory that took me forever to edit out all the bad words, and I didn't even do very good, let me show you some of what these people have been dealing with. Now, there were 4 or 5 of these reflection statements in just this landlord-tenant case alone. Keep in mind, once this happened, after he was arrested, he sued the police department. He sued the clerk of courts. He sued the other court. There's 2 different courts involved. He sued like anyone and everyone he could. That's why this is like expanding. Spiderwebbing? Is that what it's called? Anyways, so one of his filings says, let the record reflect counter defendants hired an actual lawyer for an eviction case as an exhibit while simultaneously exhibiting the grandeur yielded from decades of practicing law. In fact, the totality of expertise and consecutive value brandished by Aaron A. DuBois has forsaken my courage, withdrawn in humbleness. I admire, abstained of shame, yet further challenges the counter defendants' sequestering of guilt. I render you all as opponents, fractions never less. The others were pages and pages long of his word salad, crazy, goobly-gook, blah, word vomit. But then he, Alan, Mr. Way, proposes that all parties submit to, not psychological testing, mandatory IQ and drug tests. And eyebrows and white snow. I don't know what all that's about. I can't even keep up with this anymore. Oh, yeah.
That was so interesting.
Bitch lying and I move and I fucking move. Bitch, you got cancer. Die. Stupid ass. You sitting there lying, you know, bitch, you told me your name was Amanda. Tell me how much of a fucking lie that is. You're on the fucking original petition, you're lying. All kinds of shit. The statement of inability to pay, you changed this shit. Stupid. Let me go. I think it's events prior. Exhibits events prior. There we go. What a fucking idiot. You can tell by her body language too. Her body language, she's just looking all over the place and I can't believe I gotta say this and I'm such a liar. Like, what the? And I'm gonna appeal that shit. Stupid ass. That shit's annoying because I can't. And I move, and you're trying to make me look like a bad person, but I'm like, yeah, and I'm getting back to my trial, bro. And I got a job and got arrested. That's what the next part you need to talk about. Yes, that's the next thing you need to talk about. He said, yeah, so I basically got arrested and they followed suit and decided to do all this nonsense, but all my shit's on file. You can't reset the trial, bitch. He said the shit literally says paid. Perfect. You got the documents. I didn't share that shit. You put my shit over there in Travis County intercepted, bro. I'm glad I said that shit, bro. Out of here. Stupid ass. You're doing all this nasty shit, all this weird shit. That's why the fuck you paid for me, because I know this information. Stupid ass. Did you not look at my documents online? Just trying to lie and trying to make me seem like I'm bad. And this dude's coming over here and he's doing this and he's getting arrested. Did you look at the documents, you idiot? Yeah, bro. I haven't even talked about the simulation yet. Thank God. You're the one who is. And they're just making me say it. And I've been doing it. I'm telling you, they're fucking putting cameras in my shit and sleeping. And you know it's true. Circulating my fucking information. What do you have to say about that? Okay, so you need to talk about the jury demand. And then you need to talk about You need to show your documents, bro. Whew, let's go. I'm not even done. I'm not even done on my statement, bro. He said, here goes, can I share my screen? Here goes the documents. This is why I wasn't paying that, because they accepted my statement if they had deleted the pay. They said I wouldn't need to pay you until you did. Until that's what they told me. And then on top of that, I had then asked for any so what's it called, trial, and they just denied it. Woo! You got them on a few things here. That just didn't even have a fucking answer. Why did you put that on the fucking petition? Try to get rid of it. Let's go back in here. Ain't nobody likes me. You're just saying shit. I'm pretty sure everybody likes me right now. I don't care if they don't. Stupid ass. You're really getting and doing all kinds of nasty shit, and you want to be mad about it. And I'm trying to figure out how to tell people about it. And you're asking me everything lies. Ooh, I can't wait. I cannot wait. I cannot wait. Go back in. And you're talking so fast. Fucking process faster. I guess that lady does have to jot down everything I'm saying. But I keep getting interrupted. He said I have a motion of continuance. He said I'm not having a fair trial. I have multiple documents on how I have my subpoenas on. I have none of this shit. You're not looking at demand trial. They're not looking at nothing. You know what I'm saying? There's been a demand on there. Get back to your demand, bro. Your demand for a jury. Take notes. Demand for a jury trial.
Tenant's notice of appeal for a rent payment. Perfect. That's the next one you need to show right there. Yep. And then you're being notice for rent.
For your demand. Your jury trial for a demand. Yeah. Yeah. I counter something and then I put a fucking demand on there. And then don't let that slide, bro. Don't let that shit slide. Don't let the demand slide. You know what I'm saying? And don't let the I'm not paying rent. Like I didn't pay rent because we had everything. You know what I'm saying? And then after I didn't pay rent, it's because I didn't owe anything. You know what I'm saying? So then here we are for trial. I asked for a jury trial. We're here. I've been asked for a demand for a jury trial. I'm not playing no games. And I'm gonna show them too. And then don't forget to tell how Aaron is lying and doing a bunch of stuff that's literally against the. Ooh, and I'm gonna tell them too the date. The date. Yes, thank you. Date of. Perfect. That bitch gonna try and make me look bad. Well, you try to make us look bad. Ain't nobody care about you. You're ugly as anyways. And hold on. Don't even do it, bro. Body language is so bro. That bitch doesn't even want to say that shit. That's so weird. Why are you saying it? What if they actually are like controlled? I just know you bitches is eating. That shit pissed me off just now, bro. I had to raise my voice. Because what the f is wrong with you? Damn. I ain't gonna lie, bro. The judge is actually impartial.
This court is back in session.
Oh, shit. Oh.
There's no way.
All right, thank you for that. I know the court reporter appreciates the break and everybody else could have time to get comfortable, so good. Mr. Wade, let's continue then with your testimony so that you have time to wrap up with all of your.
Yes. Can I share my screen?
Yes.
First, nice. All right, so share screen. So how do you start broadcast? Okay.
If you just hit that, yeah, there you go.
If I say stop share, will that stop everything?
It will stop your share. They won't take
Okay.
you out of the Zoom room. It just stop your share.
Yes, ma'am. So I just want to point out that during this whole thing with the appeal after the decision from the judge, I had 5 days to appeal, and I basically submitted my statement of inability to pay. But last minute, they tried to change it. If I zoom in over here, they asked for 1,356, and I basically clarified. I had to call. I literally left work. I was about to go pay this money and everything like that, and I had to call to verify because they told me initially, since they sued for right of possession only, I wouldn't have to pay anything. Called, clarified, got
Your
that.
Honor, I'm gonna object based on hearsay.
Well, I'm about to show you. You should have waited. You should have waited 30 seconds.
No, Mr. Way, she has a right to object when she wants to object, as do you. It's okay. She doesn't have to wait. She can object. I'm going to sustain her objection because whoever told you is a hearsay statement. So that's a legitimate objection. I will sustain it. Please don't tell me what anybody else said. The exception, though, one of them to that rule is you can tell me what the representatives from Estancia may have told you, but not some other person you've not identified. So this is sustained for that reason. Let's move on and just give me the facts. I'm right. Right. I'm just this part of the process, the evidence phase is where I get the facts. And then in closing argument, you all can argue the law to me and then I'll make a decision.
Okay.
But right now,
Sure.
I just need the facts. What happened? What'd you do?
Well, it's a fact that after I corrected them, they went ahead and changed it back and I didn't owe anything. And then after that point, they actually signed off on that's Estancia Villas right there. After they corrected it for not the 1,300.
Well, hang on. If you'll go to that, I see that document, but you scrolled pretty fast. I couldn't read the other two. So I see this one. And just for the record, stop, hold on. Go back down a little bit. Just for the record, the document that Mr. Way is showing us on the screen right now. Can you scroll down just a little bit so I can better?
Yes, ma'am.
That's good. He's showing us on his share screen Tenant's notice to appeal for non-payment of rent, dated, it has a date of November 21, 2023, and then signed by Mr. Way. Go scroll down and let me just note the next one. The next document that he's showing on his screen is entitled Notice of Appeal with Statement of Inability to Afford Appeal Bond / Surety Bond, signed by Mr. Way, also, or has his, what appears to be his signature. And dated also on, looks like November. I can't tell if that's the 27th of November. Is that what it says?
Yeah, let me clarify for you. So on the 16th,
that's better. Hold on. Just let me note what they are.
Yep.
November 27, 2023. Thank you for blowing that up. Scroll down. And I'm going to note the third one. The third document is entitled, it at the top says confidential is kind of the title of the document, if you will. Dated November 21, 2023. It is on letterhead of Judge Sylvia Holmes, Justice of the Peace, Precinct 3, Travis County, in this cause number. And it is a document also signed apparently by Mr. Way with the date of November 27, 2023, which further says request to appeal by statement of inability to afford payment of court cost or an appeal bond in justice court. Are there other documents on your share screen?
Your Honor, may I clarify something for the court?
I right now, I just want to note for the record what he's showing us, and then we can talk about what it is. But right now, I just trying to clarify, is there anything else that you're showing on your screen, sir?
Yes, that's it. I just wanted to show that one. And then the next thing that I want to get to in the testimony.
Hold on, because Mr. Boyd has a question about those. I just wanted to note what he was showing us because the appellate record won't capture that since they're not being offered or admitted into evidence. He's just showing it to us. Mr. Boyd, you have a question about what he has shared?
Your Honor, on that third page, the document that titled confidential, that's actually Amanda Cantu's signature. It is a non-contesting the statement of inability to pay. So
I see. Thank you for that clarification. It was hard to read that signature and I couldn't tell it from the others, which is why I said it appears, because I am not verifying anybody's signature. But thank you for that clarification. All right, Mr. Way, you may proceed with your testimony.
So now back to the jury demand. As I was filing pro se.
No. We're not going back to that because I've already decided that we're going to proceed and I can't change what Judge Wong has already done. That is something that you can appeal to the Court of Appeals. You can certainly do that. but that's not the subject of our hearing today. So we're going to move
It's
past
relevant.
that.
I can't mention in my testimony why I request. Basically, what you're saying right now, and if I can continue for 30 seconds, please. What you're telling me right now is that based on the fact that you don't have information or you're going off of their information, I can't tell you my side of the story, is what you're
No,
saying.
that's not what I'm saying. That's not
Okay,
what I'm
please
saying.
clarify.
Let me say what I'm saying.
Mhm.
What I'm telling you is that the issue of whether or not you are entitled to a jury has already been decided by a judge. I do not work I'm not an appellate court judge. I'm a trial court judge. And so my decision gets appealed to the Court of Appeals. Judge Wong's decision gets appealed to the Court of Appeals. We're not the boss of each other, so to speak, right? He makes his rulings, and if you don't like his ruling, you got to go to the Court of Appeals. I'll make a ruling. If you don't like my ruling, you can go to the Court of Appeals, but he can't overrule me and I can't overrule him for things that have already been decided. Does that make sense? That doesn't mean that people can't ask they be reconsidered, or that certainly is something that could happen.
I hear you.
Yeah. So what I'm saying is I'm not reconsidering his ruling. I'm saying that right now, the law of the case is that he has decided that your jury demand was not timely filed. I'm not changing his ruling about that, but that is a ruling that if you don't agree with, you have a right to appeal to the Court of Appeals. Just like when we're finished today and I make a ruling, if either side does not like that ruling, either side has a right to go to the Court of Appeals. Does that make sense?
Yes, ma'am.
Okay. All right. Go ahead.
I would just like to, I have to mention that because it's relevant to the case. You don't need to overrule, but I do need to tell the story as this is being recorded.
Okay,
so
go ahead.
I feel like it's, okay, I just need 2 minutes uninterrupted.
Well, I
As a
can't
pro
promise
se?
that, but I will let you go.
Aaron
ahead.
cannot furnish, the plaintiff cannot furnish a notice of that set trial. They didn't notify me.
I'm sorry, I didn't hear you.
Yes,
The plaintiff cannot. Hold on.
counter plaintiff.
Stop. Let me tell you what I heard so you'll know where to start. Here's the last thing I heard was the plaintiff cannot provide a notice.
The plaintiff did not provide and still cannot furnish a notice of that trial date on January 18th, 2024. They never notified me. Now, let me tell you why they never notified me. On January 5th, I went to jail. On January 3rd, I had sent over evidence in this case to build my case. 2-3 days later, they processed a warrant, intercepted an ongoing case as I was trying to prove it, and just literally took me to jail. I'm working like $160,000 job if she wants to talk about character. I get off on a Friday, and then boom, Saturday, Sunday, Monday, I get out. As soon as I get out, Aaron had 0 documents inputted into the system for any discovery of anything. I get out Monday night, it's like 11 or 12 o'clock in the morning, she starts sending me documents. The next thing is like, there's a trial set, and here you go. There was never any notice at all. I get out January 9th, and they have court set January 18th. Now, January 11th, I had already set my, demand for jury. I had did it through the e-file system because they switched it from pro se, and I could just file email, and then they switched it. So I get out of jail, go in January 5th, and get out January 11th. Prior to January 11th, they never had any trial date in there. There was never any information, never any notice or anything. So I get out immediately, notice motion of continuance. I get out immediately, jury trial. I get out, and I had already had that jury trial on file as far as emailing it. So that's literally the reason why we motioned to recuse Judge Todd Wong, because I had stuff on file and they were just ignoring it. They're bypassing it. I literally have Aaron on the record, and I have the email right here of her saying that the responded email that I've been sending documents to filed in East, or she never seen it. Before they even set that January 18th trial, I had called Marilyn, her representative in her office, to let them know, hey, there is a demand on file. And then even prior to that,
Your Honor,
I'm not done.
Hang on, Mr. Boy. Mr. Way, I tried to give you some leeway here, but I think I need to get you to focus on the facts that relate to the claims in the case that I am going to decide. I'm not going to decide this issue about the jury trial. That's not going to be
so we can just appeal that then, right?
That's what I was trying to say
Yeah, all right,
earlier.
forget about it. I'll just appeal it because you guys aren't hearing what I'm saying. I just wanted this to be
Well,
recorded
it's
on
not
file.
that it's not that
Yeah, I
we're.
just wanted to be recorded
certainly-
on file when they. Sorry. I'm
It's
sorry.
not that I'm not interested in what you have to say in the position you're taking. I am interested, but I am not going to overrule Judge Wong's decision. He's made it, it's done. And if you are not satisfied with that decision, your appeal to the Third Court of Appeals is the place in which you would deal with that issue.
Oh yeah, yeah. All right, we'll just do it there.
So my point for today is just to focus on the issues that are before the court today, which are essentially a brand new trial on the eviction with the claims that the plaintiff has brought for non-payment of rent, as well as attorney's fees and other costs, right? That's all I'm here on with regard to the plaintiff's claims. Then your claims, the ones that I have jurisdiction over, which we'll sort out in a minute once I hear some evidence, right? And that's why I'm saying that at this point, we're just in the evidence phase. This is where I get facts, not argument, not legal discussion, just facts. What happened? Who did what? Who paid what? Who said what? Like who did something? Those are the facts that I'm listening for, so that then after I hear your closing arguments where you will apply fact to law, then I will make a decision, right? So give me the facts. What happened? Why shouldn't you be evicted? What did you pay? What didn't you pay? When did you pay it? That sort of thing. Make sense?
Okay. So I shouldn't be evicted because you don't want me to re-narrate this information, but the reason is the original petition. Past that, it's the next thing I just showed you, the document where I didn't need to pay anything to update until we get to trial here. Now they reset the trial. And to be honest with you, the way that you guys reset the trial, I'm not with it. And let me elaborate on that. One,
No. The trial was set. The trial was noticed. The trial was assigned to me. We're in the trial.
It's irrelevant. It's irrelevant. I hear you.
No, it's not. It's not that it's irrelevant. It's that it's not appropriate for now. That is something that you can complain about if you want to on appeal, but not for today. That's all I'm saying.
Well, I hear you. I hear you. All I'm using
I'm not
that
saying
to
it's
tell
not
you.
relevant. I'm saying
Yeah,
it's not
I hear you.
appropriate because it's beyond the scope of what we're doing today.
I
That's
hear
all I'm
you.
saying.
All
Okay.
I'm saying is, you guys, and I'm looking up the thing from Angela. It's literally a hearing, quote unquote, document. I could share my screen. She told me it's a hearing. So what I'm trying to get at by referencing the demand trial is that this is inappropriate right now. To have a trial when I'm not prepared for it because I've had so many documents, and this is why he's being recused right now. I know it's irrelevant, but I need to mention it since we're on air and we're going in. This is not an appropriate trial because it was designed to be from a jury. Is what I'm saying.
I understand that. I understand
past
that.
that-
Now, we're not going to deal with that today because that is the subject of something you're going to do on appeal. So for one more time, I'm going to ask you, please, to stick to just what is relevant for the purposes of our time together today, and that is the eviction issues. Did you pay rent? Did you not pay rent? And so forth. Now, in service of that, let me ask another clarifying question.
And there was a motion to transfer too. Sorry.
When you paid or filed, I should say, when you filed the affidavit indicating that you did not have the money to pay the appeal bond or the surety bond, did you understand that document to mean that you did not have to pay your rent also?
Ma'am, can I share my screen?
Yeah, you certainly can, but first answer my question.
am I supposed to-
Did you understand that document to mean that you did not have to pay your rent?
Which document?
Let me start over my question. Listen to my question. When you filed the affidavit that indicated that you could not afford to pay the appeal bond or the surety bond, when you signed that document and filed it, did you also think that document meant you did not have to file or pay your rent? Is that what you thought? That's my
That's not
question.
what I thought. That's not what I
Okay.
thought. The document said that I did not need to. It's not to Estancia Villas until the case is processed. It's either to the JP court or it's either to the civil court.
I don't
It
think
is.
you understand my question. Let me try again. And maybe you said, maybe you did understand it and maybe I got my answer, but let me clarify. I just want to clarify. When you filed the affidavit indicating that you could not afford to pay the appeal bond or the surety bond, when you filed that document, were you under the impression that that document relieved you of your obligation to pay your rent?
No.
Okay, all right. That's my question. You've answered it. Let's move on. Next part of your testimony related to the facts of the case, not the jury trial demand and all that. I just want to know about the facts of the eviction case. You may
Ma'am.
proceed with your testimony.
Am I on screen share right now?
Yes.
Okay. So stop screen share. Let's go to this. What does this say right here?
What I see on the screen is some email.
From Angela?
It related to a hearing confirmation, yes. But again, Mr. Way, that has to do with the procedural issues related to your request for hearing or trial or juries and so forth, which is not what I'm entertaining today. That is going to
hear
be,
you, but look
if you
below
want to talk about it, the subject of your appeal, should you decide to appeal once the decision has been made, not the subject of what we're doing today. And so I'm going to rule that that's not relevant. We're proceeding and we're in the middle of the trial. So I want to know
Ma'am,
about the
can I
facts
read
of
it?
the case. I want to know about the facts of the case. I want to know about your time at Estancia, your rent, your claims against the plaintiff. Tell me about those facts, not about setting matters for a hearing. Okay?
No, listen, ma'am, look, it literally, can I read this out loud to you, please?
No, you don't need to read it to me because I can read and I'm looking at the document and I've
It
seen
says
it.
as
I
well
understood it.
as the plaintiff notice of rent default for motion to transfer. There's a motion to transfer the case. Please
I
stop acting like
understand that. I understand
it
that.
literally says it right there. It's not just
Yes.
the merit. There's so
So,
much.
Mr. Way,
Okay,
Mr. Way.
look, there's
Way.
another one. There's another one.
Hold
Here,
on,
check this
hold
out.
on. Hold on. Are you telling me that you want me to entertain a motion to transfer today? You
Well,
have yet to say that, but if I'm
ma'am,
now understanding you
you
to
tried
say
to
that,
shut me
then
down
stop.
consecutively and consecutively and consecutively.
Stop. I will add to our agenda a motion to transfer. Now, let me point out that when I was setting out the agenda earlier this morning, and I said, there are the 4 things we're going to talk about today, you did not mention there was also this motion to transfer. Had you done so, I would have been happy to add it to our agenda. I will add it now. So I'm going to add number 5 to our list of things to do today is your motion to transfer.
Your Honor.
Hold on. It's a little late in the game for us to do it, but we will come back to that in a minute. Right now, we are in the middle of your direct examination. Ms. Du Bois is entitled to a cross-examination. I need you to finish her direct examination so we can get to her cross-examination and to any other evidence you have to submit so that we can complete the evidence phase of our trial. So I will add motion to transfer to the document, which, as you point out, includes in the notice the merits of the trial to be discussed today, which is what we're doing, along with all those other things that we've added to our agenda. Now, move on, if you would please, to the next fact.
Ma'am,
tell me about your case.
I would like to be 100% respectful with you guys, but I think you're overlooking a lot of these facts. The first thing I want to mention, if I can just get 1 minute to go off, the first thing I want to mention is that you guys were already aware that there was a motion to transfer. Why was that not on the case? I'm not even done with that. All of my documents have been on file. Nobody looked at any of my documents prior to this. I'm trying to tell you about the demand for the jury.
First of all, that is not a correct statement because I did look at your documents before the trial. So I would appreciate you not assuming things about me. I'm not assuming anything about you, and I don't want you to assume anything about me. I appreciate that you have your opinion about these things. I respect that, but I need you to respect my ruling. Here is my ruling. We are in the middle of a trial on the merits. We are hearing at the moment your direct testimony, which is about the facts that relate to what happened in the case. So I need you to focus your attention and your testimony on what happened. Who did what? What did you pay? What didn't you pay? What did they do? What didn't they do?
I hear you.
And when you're done with your testimony, then I'm going to hear argument, at which point you can tell me these other things that aren't testimony. But in the middle of your examination, I just need to hear the facts. Okay, related to the underlying litigation, related to your eviction. That's it. And then when we're done with that part of the case, I'm happy to hear these other things.
All right. Okay, thank you for clarifying that. Thank you for clarifying. So pertaining to the case, there is the original petition, and then beyond that, there is the surety that I just showed you. And my impression is that I'm not supposed to pay until we're in trial. Now, as far as everything else, I'm gonna wait to relay that to you. But as far as that
Okay.
goes, that's
Look,
it.
let me clarify. When you say I'm not supposed to pay, that's what I was getting to earlier.
Mhm.
What is it? What is
Until-
it that you think that affidavit of inability to pay absolves you of the responsibility to pay?
Thank you. It absolves,
What
since
do you think that you don't have to pay?
they sued me for right of possession only, that 1,356 was actually supposed to go to the JP courts on a monthly basis while we're going to court, is what I'm saying, right?
Okay.
To the JP court is what I'm, not to the Estancia Villas, but to the JP courts. What they done after I had to speak with them is they corrected that document, right? Which actually let me go with $0 up till now. So what I'm trying to, what my ultimate argument is, the original petition, as if I didn't do anything wrong on it. If you look and you read the original petition in conjunction with the document of appeal and the surety, like I'm not paying to the JP court because they sued for right of possession only. And I'm also not paying to the Travis County court because they sued for right of possession only. Here we are on, what is this date? February 29th, and we're going to trial. So I'm gonna hold off on how the dynamics of how the trial was set up and how I was set up and all the other stuff, because it seems like that's the only information you guys need right now.
Right now, I'm just trying to get the merits of the case figured out. And your answer to my question about what you thought you had to pay or didn't pay is super helpful. So thank you for that. Are there other facts that you can give me in your direct examination at this time before Ms. Du Bois begins her cross-examination? Anything else you want to tell me about your claims against them, their claims against you, as it relates to the pleadings on file? That's all I'm asking for right now.
Yeah, other than my countersuit and my demand, I
can tell me
just need to
about-
give.
Tell me about that as well. This is your opportunity to tell me about the claims
So the
that you have to
countersuit,
file.
I've met Jennifer Alvarado's children, and they seem very.
Okay, so hang on a second. So
Yes.
if there is a criminal allegation, I do not have jurisdiction over criminal cases, and this one is not involved in a criminal case. There's no notice to the family and so forth. So I'm not going to entertain any
criminal.
Right, because I don't have authority to do that. That's not up to me, right? And it's not part of your eviction case. So I won't entertain any of those claims that relate to criminal activity, and you have several of them in your list.
30
but
something.
I can't do that before you. I can't provide that relief. Now, that's
I'm not worried.
Without prejudice to you going to the appropriate authorities related to your criminal allegations. That's between you and the police and the DA and so forth. You can do it in another forum. You just can't do it here. So all of the causes of action that you spelled out earlier that relate to criminal cases or criminal investigations, we will not deal with those today. And any request that you've made in connection with something criminal will be denied here because I simply
I'm not worried about that.
Okay.
That was the initial countersuit, and it's in conjunction because it's relative because it's my residence and the players involved.
I understand why it's important. Yeah, I get why it's important to you. That makes total sense. I just wanted to be clear. I do not have the authority to rule on those. So all of those requests will be denied. And while we're on the subject, I couldn't, even if I wanted to, grant relief in the $200 million range because
I think it's 10 million here. Well,
it exceeds the jurisdictional limit of the county court at law, and I'm sitting as a county court judge at the moment, so I can't do that either. So what I'm asking you to do is just to finish up your testimony. If there's anything else you want to tell me related to the eviction case, because that's all the authority I have at the moment.
Yes, and that's why there's a motion to escalate the case, because this is not a civil case. It is a civil case, but there's also a countersuit, and that's why there's literally a motion to escalate to a higher court, a district court, or a federal court. To be honest, I actually said federal court.
You can file those cases in the appropriate courts if you like. That's up to you. We won't be dealing with that in this case. So all of your requests related to those will be denied. But
there's a motion to escalate though.
You can, well, I'm not familiar with such a concept. If you have a criminal case, you go talk to the criminal people. If you have a federal court case, You go talk to the folks in the federal courts, right? So my point is, I am only dealing with this eviction and the related issues to the eviction, and I want you to finish up your testimony because I want to hear all that you have to tell me related to the eviction case, and that's it. Okay, so finish up your testimony on that, and then we'll proceed.
Yeah, we can proceed. Let's see what else is there. Let me check my notes here.
Yeah, take your time.
Did I mention the date of trial set and how she wasn't able to furnish any?
You did.
Okay, yeah, that's it. They've got all my. It's cut and dry. The document and then the conjunction of it with the other document. Here we are.
All right.
And then
So
the rest of it I can tell you about.
If you're done with your testimony on the facts related to the eviction, then I'll let Ms. Du Bois ask any questions if she has any for you. All right. Ms. Du Bois, your opportunity for cross-examination begins now.
I have no questions for Mr. Way.
Okay, so she doesn't have any questions for you. And I think I've asked you for the clarification of the things that I wanted to ask about in terms of the payments and all that. So I think I don't have any other questions either. Is there anything else related to the eviction case, Mr. Way, that you want to offer at this time?
Can I talk about the stuff that I wanted to talk about, or are we waiting for another time?
Is it related to the eviction?
It is related to the eviction, but you just
It's
told me not to
related-
talk about it.
No, I'm telling you now is your chance to talk about the facts related to the eviction issues. Did you pay your rent? Did you owe rent? Did you not owe rent? Were you
Yeah.
required to post a bond? Did you
Yeah.
post the bond? Did you pay into
Yeah,
the
I filed
registry
all.
court?
Yeah,
Did you
perfect. Yeah,
not-
let me just summarize.
Those
It's
are
30
the
seconds of a
facts.
summary. I
Let me
paid.
finish, please. Those are the facts that I want to hear about related to the eviction. The motion related to the setting of the hearing or whatever your complaint is about that, the jury demand, those are not things that I'm interested in hearing about right now. We can talk about that later. Right now, I'm only interested in the facts related to the specific issues around the eviction. So anything else about that?
Yeah, it's a fact that I proceeded with the legal proceeding, or I was conducting the legal proceeding accurately. It's a fact. It's a fact that I interpreted the information from the original petition correctly. It's also a fact that I had clarification from the JP courts or when we escalated. So I have these documents to protect me as far as those go. Everything else, I guess I can't talk about until you're ready for me to talk about.
I want you to talk about anything else related to payment of rent.
Yeah.
Like if you made
Yes,
a
ma'am.
payment, I want to know about it. If you didn't
Yes.
make a payment, I want to know about that. I want to know about anything related to the eviction case before we move to the next thing.
Yeah, that's it. I have my documents on file.
All right. Anything else, Mr. Boyd?
Your Honor, I have no questions for Mr. Way.
All right, that will conclude the evidence phase of our trial on the eviction. We will now move to
I can't even hear you.
Yeah,
Hello?
I think the judge is frozen. Hang on just a second.
Okay, thank you.
Yeah, because I see everybody else moving except for her.
Man. But hidden appeal, and then I send this to the Western District. Screen browsing, live screen browsing Zoom stopped due to an Oh, can you still hear me?
Mr. Way, we can still hear you. We need to get our
Yeah,
connection.
it stopped.
Yes, I can still hear you.
Awesome.
Hello?
All right, Judge, where you left off at before you froze, you were saying this will conclude the evidence phase of our trial on the eviction. We will now move to, and then you froze.
Okay. All right, closing arguments is what I was saying. So now we're gonna essentially closing arguments, Mr. Way, is just an opportunity to summarize the facts and apply those facts to any legal arguments, right? Like state the statutes that might apply or legal theories or cases that relate. to the arguments for why I should grant or should not grant the relief that's been requested. And once we finish with both sides closing arguments, we're going to take up these other issues that you want to talk about to the extent that they're relevant for us to do so today, particularly the motion to transfer and whatever else. So we'll get to that in a minute. Right now, closing arguments on the eviction itself. Ms. DuBois will begin, and then we'll hear from Mr. Way. And because she's the plaintiff, Mr. Boy gets to wrap up. Go ahead, ma'am.
Your Honor, the evidence in this case shows that Mr. Way.
Oh, wait, I'm sorry. One thing, let me just clarify. Mr. Way, since you indicated that you don't have anything else, I just want the record to reflect correctly that you have rested your case subject to your arguments on the other motions before the court, like the transfer and so forth. Is that correct? You rest your case at this time?
Yes.
All right. Okay, go ahead for closing arguments, Mr. Boy.
Your Honor, the evidence in this case shows that my client has a superior right to possession. There's a lease contract between Mr. Way and Estancia Villas that has been offered into evidence. There's evidence that Mr. Way failed to pay rent beginning September 1 of 2023, which is a default of lease. That default of lease allows my client to possession of the premises. In eviction suits, that is the sole issue for the court to adjudicate. There are no counterclaims. Mr. Way failed to pay rent, and so my client is entitled to possession of the property. They're also entitled to the back due rent that is owed to them. And the evidence showed today, Your Honor, that because he has not paid for each of those months, Mr. Way is liable to my client for $8,136. Your Honor, the contract between the parties.
So let me stop you there only because I just will need to clarify whether or not you have any rebuttal evidence to Mr. Way's testimony. You didn't tell me that you did, so I moved right to closing arguments, but now you're making an argument that he owes X dollars, the $8,000 sum, for example, as opposed to some other number, because his testimony was that some amount of money, roughly $4,000, was paid on his behalf. So you didn't ask for any opportunity for rebuttal evidence, but I want to make sure that you've got that opportunity should you need it before we wrap it up. Or are you simply relying on the evidence in the record, given the pay record?
Yes, Your Honor, I'm relying on the evidence of both my client's representative and the records and the exhibits that we've offered.
I just want to make sure that everybody has every opportunity they're entitled to. So, all right, with that, then, Mr. Way, what she's saying is she does not want the opportunity to add any rebuttal testimony to what you testified to. So what I have in the record is what I've received so far in terms of the testimony from the three witnesses, as well as the documents that were introduced and admitted into evidence. And with that, you may proceed with your closing argument, ma'am.
My closing arguments are
her. She was wrapping up.
Sorry, I apologize.
I said ma'am. Sorry. Go ahead, Mr. Boyd.
I didn't even hear you.
That's okay. Go ahead.
Your Honor, the contract dictates that my client is entitled to an award of attorney's fees here, and we've properly presented evidence as to my client's entitlement to $2,600 in attorney's fees. Your Honor, my clients testified that Mr. Way has failed to pay rent. Mr. Way is the person responsible for rent under the lease contract. There's evidence presented to the court that testimonial evidence that he failed to pay rent, any rent, except for $720 at the beginning of his tenancy. And this is also proven by Plaintiff's Exhibit 5, which was the ledger showing that Mr. Way only paid $720 when he moved in. No other entity has paid, no other payments have been applied to Mr. Way's account with my client. And so, Your Honor, this is a simple non-payment of rent case. There's additional reasons for which Mr. Way has defaulted under his lease that my client has provided as well, which is the conduct-based violations that was pled. There's evidence on file to show that Mr. Way was arrested for a criminal harassment charge that is a breach of the contract and therefore a default under paragraph 23.1B. And so again,
let me ask you about that. Hold on, let me ask you about that. Does your lease agreement indicate that anybody that is even arrested, even if they've not been convicted of something, is a violation?
That's correct, Your Honor. Criminal conduct under paragraph 11.1A.
Well, it's not criminal unless you've been convicted of it, right?
Your Honor, he has been charged with a criminal offense of
But
harassment.
that doesn't mean he's guilty of it, right? I mean, people get arrested all the time and then they go to trial and they're
but the
acquitted.
least-
That
but the
doesn't mean
least-
that in fact, that means the opposite of
Your Honor,
criminal
the-
activity. It means they've been acquitted of what they were accused of. So I'm just trying to understand if your contract with Mr. Way says that he has to have actually committed criminal conduct or simply that he's been accused of it.
Your Honor, the lease contracts prohibits a tenant from engaging in criminal conduct. And then under the default of lease provision, it provides that it is a default of the lease for you or any guests or occupants to violate the lease, criminal or other laws, regardless of whether or where arrest or conviction occurs. In addition, Your Honor, 11.1B prohibits engaging in disruptive, harmful, loud or obnoxious behavior. My client testified concerning that conduct, as well as threatening conduct against others, including staff. That was 11.1C. My client testified concerning
Objection,
threatening
hearsay.
conduct.
Objection, hearsay. Where's your evidence? Where's your evidence of it?
Mr. Way, hang on. I'll overrule your objection because we're not in the evidence phase. She's not offering evidence at this time. She's just summarizing what she believes the evidence has shown, not giving evidence. So that's the difference. Go ahead.
Ms. Cantu also testified about Mr. Way's conduct at the property prohibiting or affecting their business operations, which is a violation of 11.1D. And so for these reasons, these violations of the lease are a default under paragraph 23.1B and is another basis for my client to seek possession and terminate Mr. Way's right of occupancy of the premises. So at this time, Your Honor, my client has the superior right to possession based on the contract, and they are seeking the amount of back due rent and attorney's fees, and we'd ask that the court enter the judgment that we have proposed.
All right, thank you. Let me ask another point of clarification. You've indicated the back due amount that you seek, which if I understood your calculations correctly, were calculated by multiplying 1356, which is the amount of the monthly rent, times 6 months. Was that correct?
Correct, Your Honor.
But I didn't understand, and if I understood your calculation earlier, you calculate that number to be $8,136, correct? I didn't check your math. I'm asking about that now, and just so you can know where I'm headed with this. If that's the calculation, I don't see where you have given Mr. Way credit for the $720 you all admit he paid. And so would it not be?
Your Honor, this is just for the non-payment of rent. In eviction cases, we can only seek a judgment on the non-payment of rent. And so the $720 that he paid at the beginning of his tenancy would have been for prorated rent for the month of August.
Objection.
I see. So you're not
Objection.
asking for, hang on, Mr. Way, I promise you're gonna get your turn. I'm just asking her to clarify what she's asking me to do, and I'm trying to check her math. So let me get clear with her about what she's asking for, and then you can give me your closing argument. So that I'm clear, the $720 that he paid, that you all admit that he paid, was not applied to September, October, November, December, January, or February, because it was not due for those months. It was due and paid prior to September of 2023. That's the position you're taking?
Yes, Your Honor, and that is evidenced by Plaintiff's Exhibit 5.
All right. I just wanted to clarify all of that so that Mr. Way understands what happened to that 720 and whether or not it was credited or not credited. And I want to understand that so that I am clear about what you're asking me to provide you a judgment for. Okay, thank you. Anything else?
No, Your Honor.
All right, very good. Thank you. Mr. Way, it is now your opportunity to give me your closing arguments, and you may begin your closing argument at this time.
Yes, so I moved into Estancia Villas August 21st, and I had paid the $720, fell on some hard times, and there was a delay in payment on my behalf. UDR, a $15 billion corporation, proceeded to collect the asset of Estancia Villas or Steadfast Management. They changed everything up. So September 15th, I couldn't even pay rent. Nobody in the 341 buildings here could pay rent until around September 15th. On the 25th of September, Jennifer Mercado showed up and gave me a notice to vacate. Keep in mind that I had moved in with rent paid $720 advance deposit and everything for September, for the 1st of September. So between the 1st of September and the 15th, I wasn't even allowed to pay. And then 7 days, or not even 7 days, 10 days after that, she shows up with a notice to vacate. I didn't even get 1 month to do anything. It was just a notice to vacate. In addition to that, I made multiple attempts that I do have on record and on file to pay a portion, even being 80%
Your Honor,
of the
I'm
rent.
going to object just because there's no facts into evidence or testimony in
It doesn't matter.
ways.
I'm going to overrule the objection.
Yeah, I'm
but
just telling the story. I'm summarizing.
Yeah, but Mr. Ware, let me just point out, technically she is correct in that your argument must relate only to those things that were produced in evidence already. And what she's arguing is this is new information. I'm just going to ask you to tell your story based on what we've already discussed. I don't want you to.
Okay, I hear you. Well,
all right, go ahead.
Yeah, for sure. I got you. There's a book on file as far as the e-files go and all of my motions and documents. Everyone's been overlooking. This has been going on since December. This is the whole reason why everything's becoming complicated now. There was just literally an eviction appeal. It went to another plaintiff petition for JP courts, and now there's like 10 involved. You have been assigned to be the judge on all cases in the with respect to Travis County at law. So essentially, it's like a cluster. I don't want to use the word here, but basically what I'm trying to get at is that all of my documents, including what I just mentioned, was on file. The judge could have seen it, Aaron could have seen it. And when I say that, I have literally written a book on this, what my experience has been. And it includes me showing up on August 21st and then not having the ability to pay rent until the 15th, and then getting a notice to vacate on the 25th. And then after that, having a month before trial, and then it being paid on my behalf because they've been monitoring me inside here this whole time. And then boom, the original petition in conjunction with my appeal. And that's why we're here right now. And just to further reiterate, there's a demand for a jury trial on here. I know that now is the appropriate time to talk about it. So as pro se, I was able to file that electronically through email. That should suffice as far as me requesting, because I had 4 subpoenas literally delivered by the constable through the same channel. So it doesn't make any sense for my demand to not be on there. In addition to that, when I came out of jail, this is the main thing right here. Judges, I know you can't overrule it, but I'm mentioning it because it's a fact. Like the trial that's being handled right now, it's inappropriate. For one, Angela told us that this is going to be a hearing. So I'm not prepared because I was under the impression.
But hang on that point, if you look carefully at what you received from Ms. Burks, which you shared with us on your screen, there's
another one prior to that. I hear you.
What you shared on your screen, which you asked me to read, which I did, indicates very clearly that in addition to your motion to transfer and other matters, today you should be prepared for a hearing on the merits. That's spelled out in the notice that you received. I just want you to
with the jury trial. With the jury is what I was talking about. I'm sorry. That's what I meant.
You meant that it was a hearing, and I was reacting to your point about it's a hearing and not a trial. I just wanted to point out that the notice that you shared with us this morning very clearly indicates it's going to be a hearing on the merits, meaning a final trial on all the matters related to the eviction case. I just wanted to point that out. Go ahead.
Okay. Yeah, so there's supposed to be a demand. It's supposed to be a demand trial. And what I'm trying to get at is that the fact that they've been doing a lot of sneaky stuff. So Aaron mentions, oh, well, this dude, he broke the lease. He violated the lease by committing a criminal act. First of all, I haven't even been proven guilty. I have a whole lawyer and they're about to dismiss the case, to be honest with you. I'm just saying. Independent of that, I have information relative to the case. Hold on. I don't even know how to put this.
Well, let me stop you by saying, as long as it relates to the eviction case, if it's about some criminal conspiracy or something else.
That's what I'm trying to stay away from. Yeah.
Yeah. Stay away from that. Just just give me your closing argument on the eviction case.
I'm just trying to get at the trial wasn't set appropriately because had I gotten out of jail, Aaron still cannot furnish any notice like, hey, we're letting you know that there's a trial. As soon as I get out, they're just like, hey, there's a trial. And then they reset the trial and I let them know that there's also a demand. At the point where they reset the trial, they should have also considered my demand for, so the 17th, due to weather, inclement weather and pipes bursting, for one, they couldn't even provide notice to me, the defendant, that there was a trial in state and I had just gotten out of jail. There was no fair warning or anything like that. They're just like, hey, there was an act of God. Literally, the trial is reset. Now they're already aware of my demand for the trial and they just reset it. Here we are. They reset, they had the opportunity. And I've told everyone, not just you, Aaron, Colton, everybody, there's a roster of people that have been stressing out, sending emails, linking emails, e-filing for this demand trial. On the 18th, not only did they not provide anything prior to that, as far as setting that trial, but then they also, in conjunction, the same violation that I went to jail for, Aaron and all of the representatives here decided to imitate and mimic that with Travis County Sheriff's Office, and then literally got declined. So I went to jail for harassment, trying to plead my case. I get out, they file another harassment charge on me and then get declined on it and then literally try to spin the argument and then without any notice, try to set trial. Then they reset trial and then they say hearing and I have a demand trial since the 11th. And not only did I file this thing on the 11th, but Travis County's website says within 48 hours, they're gonna process. So they actually accepted it on the 16th of January, 2024. They let 3 days extra elapse. What I'm saying is I've been on top of it as far as submitting my documents in the proper way. And basically they've just been overlooking it and trying to do other tactics in conjunction with different departments to minimize me and prevent me from speaking. There's a lot going on here. Now, in regards to the other, if I can share my screen with you again. Here it is right here. It says Judge Livingston has been assigned. Can I share my screen?
Yes.
Okay. Share screen. Start broadcast. Okay. So it's a little blurry, but the state of Texas, they basically assigned you to all the other cases. It's almost as because the cases piggyback off each other.
Okay,
And
so
I filed
Mr. Ray, hold on. We're
Go
gonna
ahead.
deal with other cases another time. We
Sorry,
can
I
talk
didn't know this
about
was the
that at
time.
No, that's all right. We're gonna deal with those at the end of the hearing because we can clarify what happens in those cases. As I understand that order, it only mentions this one cause number, but we'll clarify that later. Right now, again, I just want you to stay focused on the eviction case.
Okay. So yeah. Here goes their notice. There goes Jennifer, aka her name is technically Amanda. I'm telling you, she told me, oh, it's not even relevant at this point. It is kind of, but she shows up with a notice, and here it goes, right here. Can you guys explain this right here? There's literally nothing that I've done, making inappropriate or derogatory remarks. They don't have any evidence of anything. That's what I'm saying. So they're just trying to do character assassination at this point in time. Not only did they swindle the system and do all kinds of stuff, get a trial set without any notice or anything to me while I was in jail and I was providing documents, they also can't provide where and when I did any of this stuff right here, especially considering the initial petition, how it didn't have any lease violations on it. And then fast forward to this time right here, December 6th. There's literally like, what have I done? And can you please elaborate and explain and document it and put it on camera, please? Because you can't just say that. It's character assassination.
Mr. Well, hold on. When she makes an objection, you need to stop. But before
I didn't hear it. I'm sorry.
That's all right. Don't worry about it. I need you to focus just on the eviction. And you don't get to ask any questions of her at this moment. So move on.
Okay. Yeah. And so just in summary, basically, it's just a mistrial. It's a mistrial from the very beginning when they processed it without any legitimate cause to evict me. And that's what the appeal was for. I was in a position, things were paid on my behalf. It's literally a document. And the document isn't even 100% accurate because they forgot to add that $720, unless it's just for unpaid rent, in which case they still put the $4,068 as claimed rent as of that time. There is no pursuit for unpaid rent, and there is no pursuit for applicable attorney fees. In addition to that, the document that I have for surety approved by JP3 and escalated to Travis County and also signed off by Estancia Villas at that time, it basically minimized my $1,356 rent payment to $0 to the JP court at the time of court, in which case I actually demanded a jury, so we shouldn't even be here in the first place, is my argument. And that's it.
All right,
right now.
thank you.
Yes,
Ms. Du Bois, anything further? Mr. Way, if you don't mind stopping your screen share, we'll hear
How
from
do you do
Mr.
that?
Boy. Just hit that red stop share button. Thank you. Go ahead, Mr. Boy, anything else?
Your Honor, again, the facts and the evidence presented to you today show that my client has a superior right to possession. Mr. Way has now argued that he was not provided notice. In the court's file is a file marked copy of a notice of hearing and trial for January 17 that was served on Mr. Way on the email address that he provided to the court in his statement of inability to pay. There's simply no defenses that Mr. Way raises that do not entitle my client to possession of the property, as well as the amount of rent that he has failed to pay. And so we'd ask that the court enter judgment in plaintiff's favor.
Thank you. Just another point of clarification, Mr. Boyd, do you have handy, and maybe you could share your screen, a copy of your pleadings in the county court filings so that Mr. Way can see what you spelled out in terms of your request for unpaid rent, attorney's fees, and other matters? There seems to be some confusion, and maybe the confusion is on my part perhaps, and maybe everybody else is clear, but I think it appears to me that there may be some confusion about what your client requested in justice court versus what you've requested in the trial de novo. And so I just wanted to be clear so that I'm clear, because it's my understanding that when you get to the county court and you file pleadings on file in this trial de novo, this new trial in the county court at law, at that point, your pleadings can ask for any number of things that may or may not have been part of the prior proceeding in justice court. And so I think there may be some confusion about that. And I thought it might be helpful if we just kind of scroll through that petition. And so if you'll just slowly scroll down to the requested relief and the allegations regarding unpaid rent. So let's stop there. So we can see now on page 2 of the plaintiff's petition in county court, there are allegations of a breach of contract of the lease agreement for the non-payment of rent and other sums of money. If you'll scroll down further on that same page, there's also an allegation of breach of contract for other prohibited and criminal conduct, which we've discussed. And if you'll scroll down further, you'll see in the county court filings by the petitioner, they describe what they believe are violations of the lease. Keep going down if you would, please. And then there's also a request for attorney's fees. Keep going. And then at the end there on page 3 of the petition filed by the plaintiff in the county court petition, there is also a request for judgment that asks for forcible detainer, immediate possession, and so forth. And then if you'll keep down now to page 4 there's a requested relief that asks for essentially everything they've spelled out. So you can stop your share now. I just wanted some clarification so that we're all clear that what the plaintiff requested in the JP court may be, can be, and apparently is different from what they asked for here. Sometimes that's because landlords are interested in just getting their property back so they can rent it to somebody else, and they're willing at that point to just forego the rent because what they really want is to be able to rent it to somebody new. They cut their losses, if you will. That's sometimes why.
What I'm saying is that
I'm not done.
Oh, sorry. Go ahead.
And so sometimes that's what's done. I don't know if that's what their thinking was here or not. I don't have any evidence about that. I'm not making any decisions about them. Simply pointing out that that explains sometimes why what we see in justice court might be different from what we see in the county court proceedings. Here, it's very clear that in the county court proceedings, the plaintiff's petition does in fact ask in writing in their petition for everything they've asked for here today. So there seemed to be some confusion about all that, and I just wanted to clarify that. Second thing I want to clarify is that the affidavit of inability, and again, I don't know what people were thinking or what was in their understanding, and I'm not making any decisions about that because there's no evidence to me about that, and it's not something I have to decide necessarily. But I would point out that often there is confusion by folks about the affidavit that indicates that you don't have the ability to pay the appeal bond or the surety bond. As I understand the law, that does not absolve you of an obligation to pay your rent into the registry of the appropriate court. It has effect related to your inability to pay the appeal bond or the surety bond. Those are really two completely separate and different. Mr. Way, it's my turn. Two completely and separate things. So I realize that here, lots of things going on and people have different understandings about all of that. The way to resolve that, if you are unhappy with the decision, like in the JP court, somebody was not happy with that decision, you appeal that to the county court. The county court makes a decision. If you are not happy with that, you get to go to the next level court, the Court of Appeals.
Perfect, yeah.
And then beyond that to the Texas Supreme Court. So there are checks and balances, and there are opportunities for either party to go to the next level, if you will, if you're not happy or satisfied, or you think that there was a legal error in the court you're in, you have the opportunity to have that reviewed by a higher court. And so I know I said that earlier, and I think it bears repeating just because I want to be clear that everybody has multiple opportunities to have their day in court and get their issues heard and resolved. And that's true for the decision on the merits. That's also true for these preliminary rulings like the motion on the jury trial and so forth. So there is and will be ample opportunities to flesh all that out in the appropriate forums. Now, before we get a ruling and we wrap up for our time today, we still have a couple of other things to talk about. Mr. Way, tell me if you would, what your motion to transfer is about. Once you've done that very briefly, then I will hear from Ms. DuBois about why she thinks it either should not be granted or is not timely. I do have a concern because I believe that those motions, depending on the nature of the motion and what you're seeking, is something that might have been dealt with prior or should have been dealt with before today. I don't know. Tell me what it is you're requesting in your motion to transfer.
Yeah, the motion to transfer is strictly based on biased decisions made by Travis County at Law 1. That's what I need to get out of Travis County at Law 1 because you guys have been taking advantage of me seriously. For one,
Wait, hold on. I just want to know the nature of the motion, not all the details why you think that motion should be granted. I'm not asking that question at the moment. First, I'm just asking, what is it that you want in your motion to transfer?
First of all, I wanted this to be a actual hearing, actual trial, not a hearing. And I wouldn't have done it online because I wanted to do it in person. So the reason to transfer the case was because they put an order of constraint that was vague, that wasn't specified.
You want to transfer what to what is my question. What do you want to transfer?
I want to transfer this case to another county. And I also there's another motion to escalate higher. So there's a motion to escalate higher, and there's also a motion to transfer out of Travis County because they've been biased. And I've also reported that judge to the State Commission on Judicial Conduct. I've reported him already.
Okay,
on top of that, he's recused himself.
Hold on. So that's what I was asking. What is it that you want to transfer from what to what? Because
I want to transfer this case.
Right.
This case wasn't even supposed to be conducted here because it's biased.
Okay. I just want to clarify what the motion is about. And just so I'm clear, I'm going to repeat back what I understand you're saying. Okay. You wanted this cause number, this CV 23005479 case to be transferred out of Travis County to some other county in Texas.
Exactly.
Okay. All right. That motion is denied. I don't need to hear argument about that because I do not have the authority to do that. We have jurisdictional rules, venue rules, and compulsory venue provisions and mandatory provisions related to where a case must be brought. And it's very clear that a Travis County property and a Travis County eviction must be brought in Travis County. So I don't have the authority to do that. However, as I've said, if that decision that I've now made denying your motion to transfer out of Travis County to some other county is a decision that you're not happy with, that again is something that you can take to the Court of Appeals. But for today, I simply don't have that authority. So I'm going to deny that motion to transfer.
Your Honor, for purposes of the record, I just want to also point out that Mr. Way filed the motion to transfer venue on February 2, and pursuant to Texas Rule of Civil Procedure 257, due to his allegations of bias, he would have had to have signed that by affidavit, as well as have at least 3 credible persons in Travis County attach affidavits to that, and he failed to do so.
All right. That motion is denied. So I can't deal with that. Now, there are another matter related to some other cases that you have pending in Travis County. Is that right, Mr. Way? Okay.
Yes, ma'am.
So let me here's what I want to say about that. I am aware only of this cause number related to the eviction with Estancia today. What I would ask you to do is first confer with whoever is on the other side of that case, whoever's representing who you're suing, or if they're representing themselves, email or call or coordinate with those folks and with Angela Burks to clarify 2 things. One, what's the cause number? Or a couple of things. One is what's the cause number? 2, when are you all ready for a hearing or a trial or whatever proceeding you need me to preside over? When are you going to be ready to do that? And then send in to Ms. Burks, Angela Burks, whatever matters you need me to hear. So if it's a trial on the merits, fine. If it's a trial, then I can have access to the pleadings and so forth. If it's a hearing on a preliminary motion, for example, fine. Just let me know. She will let me know, but I need you to confer with whoever's on the other side of that case so that it's clear what other pieces of litigation are pending that you need me to hear. And then I will clarify my assignment with the regional presiding judge about whether or not I'm needed and assigned to those other cases. But the first step is for you to communicate with whoever's on the other side of those cases to figure out, are we ready? What are we going to hear? What do we need the judge to do? And when can we be ready for those things to be heard so that a hearing or a trial or whatever can be scheduled on those matters at a time that's convenient to my schedule and to your schedule and to the opposing counsel's schedule. So that's the first thing that you can do. And when you've communicated that to Ms. Burks, she'll let me know that so that I can then work with her on a scheduling issue so that we can all be here and available on the same time. And we can do that either in person or on a remote hearing. Either one is fine with me, as long as it's a convenient date and time for everyone that's involved. So that's what I wanted to say about those other matters that are pending. The final thing I want to say about these sort of other matters is Mr. Way mentioned that he wanted to have something happen in person. I just want to point out that I was told that a remote hearing was requested. I don't know if that's
for the hearing,
accurate.
not the trial.
We use the terms trial and hearing interchangeably, particularly when we say on the merits. That means the whole shebang to us. So I appreciate that that might not be precise and that might be confusing. I get that. But when you are told in a note or a notice that the merits are going to be decided, that is a final matter, right?
Okay, then I had objected to that.
A trial.
To the case.
I'm not arguing about it. I'm just telling you
Okay.
what I was told. That's all. My point here is in offering clarification and explanation for what I'm doing and why I'm doing it, because that is the information I was provided. I'm not saying it was accurate, not saying it was correct. I'm just telling you that's what I was told. So I was told we were doing a hearing on the merits. I was also told that the parties agreed to a remote proceeding. And that's why we conducted it remotely. I was perfectly happy to show up in person, but I was told that the request for a remote hearing. And so that's why we're having this hearing in a remote venue. All right. So that's the information I have regarding all of the other matters. I don't believe there are any other sort of other matters other than the merits of the case. And
There
if
is
there
one.
are, what's that?
It's that considering the original petition, there should have never been an eviction to begin with. We shouldn't have even been here. So anything after that point, now you're asking for all types of stuff, is nonsense, because there was zero cause in the first place. You can't even be here, is what I'm saying.
I understand that that's the position that you take, and that's one of the reasons why I wanted Ms. Du Bois to show us her petition so that you could be clear and we could all be clear that when you get to a trial de novo in the county court, which is where you are now in the county court at law, you get a trial de novo, meaning a brand new trial with brand new pleadings, a brand new request, and brand new allegations, even perhaps.
Well, having said that, they didn't subtract
Stop. Let me finish, please. So
Appeal,
that's
for
one of the
sure.
reasons why I wanted to go through that process of going through the pleadings, because everything in that pleading is before the court. I understand the position that you're taking about feeling like you hadn't done anything wrong, feeling that, you know, people had it in for you. I understand all that you've testified about that, and I'm taking that into consideration. I'm simply pointing out that all of the issues are before me at the moment, and I'm going to make a decision about that. And I want to just clarify, there's nothing else other than the merits of the eviction case now that has to be decided. Is that right?
Your Honor, except for our motion under 510.9C.
Well, that includes one of the requests you're already asking for, which is immediate possession. That's redundant to what you're already asking for in the case. So I think we'll get that.
Okay.
It'll be subsumed.
Well, you guys are
essentially.
surely getting
Just that-
appealed.
Just that, Your Honor.
Just know that. I'm not
Just-
here for,
yeah.
and then there's,
So
just
stop,
know
Mr.
that.
Way, hang on. She's trying to clarify
nonsense.
something. Excuse me. She's
Right.
trying to clarify something. I just want to be clear
Just-
about what she's asking me for. I
Just-
appreciate that there are different avenues to the same location, but I'm going to deal with all that you've asked for and cover all the requests as it relates to the substance of the eviction. Is there anything other than immediate possession, rent, attorney's fees, and the criminal conduct?
Demand.
Is there anything else?
Escalation.
Excuse
You're
me,
right.
is there, oh, please, you both have to wait until I'm finished, because A, it's just rude, and two, Miss Duet can't take it down when we're all talking at the same time. Let me finish, please. I'm simply asking if there's anything else other than related to possession and rent and so forth and all that. Is there anything else that we've not dealt with that is supported by a pleading on file in this case? Yes or no?
Your Honor, I just simply want to clarify that plaintiff is requesting the judgment be signed as well as the order for immediate possession. That is all.
I understand that. I think that relates to the substance of the eviction. That's going to get dealt with. Is there anything
Get
else?
appealed, for sure.
Is there anything else, Mr. Boyd?
No, Your Honor.
Is there anything else, Mr. Way?
Let me ponder for a second.
Okay.
To the merits of the eviction, without anything else? Yeah, without anything else, nah.
Okay. All right. Then I
Just the
am
original
now-
petition.
Sorry?
Just the original petition and where we are now with respect to where we
Well,
are now.
Yeah, you've made that argument. I understand
They
that.
need to dismiss the case, to be honest, and restart and sue me for rent is what needs to happen.
I
That's what needs to
understand.
happen.
I understand your position about that. I get that.
Mhm.
I understand. You've made that real clear. I understand that. I think Mr. Boyd has made her client's position very clear. I get that.
Mhm.
I am now going to rule on that because I think we have dealt with everything else.
Mhm.
Make sense? Okay. All right. Here we go. First, the plaintiff's request is granted in part and denied in part. The part of the plaintiff's request that is denied is a judgment and eviction based on this allegation of criminal conduct. I simply think there is insufficient evidence. Mr. Way, I need you to mute your microphone because you're
Sorry.
editorializing and I can't have that interruption, please. Just mute your microphone if you would until it's your turn. Okay. So the part of the request by the plaintiff based on criminal conduct is, I believe, insufficient evidence to prove that. And so that request is denied. The part of the plaintiff's request that is granted is in all other respects. I do not find credible evidence that rent was paid when it was due. There is ample evidence that Mr. Way paid only $720 in the month of August of 2023, and that he has not paid a penny since then, even though the lease agreement requires that he pay $1,356 per month. Those payments were due on the first of the months of September, October, November, and December 2023, and January and February 1, respectively, 2024, and there is no evidence whatsoever that he paid any of those sums. I believe that Mr. Way thought that he was not required to do so. I don't believe that he is correct about that, and so I do find that he owes the sum of $8,136 for 6 months of rent at $1,356 per month for a total of $8,136. He's not paid that sum. He owes that sum, and so his until judgment in favor of the plaintiff is granted in that amount. There is some testimony by Mr. Way that some roughly $4,000 or so, $4,068 was paid on his behalf by the representatives of this big corporation that owns the apartment complex. I do not find that evidence to be credible. And so I don't think that that the managers who are employed there seems unlikely to me that they would be paying rent on a tenant's behalf to the tune of $4,000. I simply just don't find that credible. And so I'm not going to give that any weight. Mr. Way moved in. He hasn't paid the rent from September to now. He owes it. Judgment is granted for the plaintiff in that amount. There was a request for court cost. I'm going to deny the plaintiff's request that Mr. Way pay those. I'll order that each party pay their own court cost, if any. And so if you have court costs, you pay your own court costs. There was also a request for interest sort of in general on the sum that I've now ordered the judgment for in the $8,000 amount. I will not order any pre-judgment interest. I will order post-judgment interest until that sum is owed is paid in the amount of 6% per annum. There was a request for attorney's fees since the plaintiff has prevailed on their claims, at least prevailed in part on the request for the eviction to the tune or to the on the ultimate issue regarding the non-payment of rent. So I do find that $2,600 in attorney's fees for all that's been done throughout the case is a reasonable and necessary fee, and will order attorney's fees. Those attorney's fees will be due and payable on or before April 1, 2024. That way I'll give Mr. Way some opportunity to pay that. He's indicated that he has a sufficient income. He indicated his income was in the $160,000 range. And so despite the affidavit of inability to pay the appeal bond, he's testified today that he has income sufficient to pay the attorney's fees. And so that sum will be due by on or before April 1, 2020. That's okay. You can object, but right now you got to pause your thoughts.
Sorry.
Your
I never said that.
on.
I just want to clarify. Gotcha.
Well, I'm sorry. That's what I heard. If I was misheard you say that, or maybe
Can I correct you?
Sure.
So the interception from Travis County Sheriff's Office prohibited me from maintaining my job.
You can correct
So I don't
me
have a job,
about
is
what
what
you
I'm trying to
said
say.
about the $160,000.
I was making $160,000. I had gotten the job as a high-end job. Travis County Sheriff's Office arrested me, which prohibited, I got out of jail and lost a $160,000 job.
You lost that job. Okay.
Yes,
All right.
ma'am.
Well, that's great. Well, I tell you what, then, based on that information, I will amend my order, and I will give you until May 31 to pay the attorney's fees. I'll give you a little more time to get that paid. So I'll change that based on that information. And thank you for clarifying that. I will order the payment of the $2,600 on or before May 31, 2024. I do find that the plaintiff has a superior right of possession and will grant immediate possession to them because they are entitled to it. And I don't think there's any, I think the evidence is clear that you can't rent a place, not pay the rent, and then continue to live there. So I do believe that they're entitled to immediate possession. And I believe that the writ requested by the plaintiffs in that regard for immediate possession is both justified by the evidence and appropriate under our law. Let me just check and see if there's anything else. I think that's everything that covers all of the requested relief. To the extent that Mr. Way has counter claims on filed, they're all denied because they are either in excess of the court's jurisdiction regarding the 10 million or $200 million in damages that he's requested for what might be considered tort claims. And then with regard to the criminal claims he seeks, obviously I do not have the jurisdiction to deal with those matters, but I think he understands that if he wishes to pursue those, he has other avenues, both in the federal courts or in the prosecutor's office or the police with regard to other matters. And I think he understands that. We've explained pretty thoroughly the right of appeal that each party has if they don't appreciate this proceeding and the rulings that I have made today. So here are the next.
How long do I have to
steps.
appeal?
I can't give you, that's technically legal advice, which I'm
5
not
days?
allowed to do.
Thank you.
I said I am not allowed to give you legal advice, and so I can't answer that question.
No worries. As soon as this is done,
That
As soon as
up
it's
to
done.
up to you. I would say sooner the better, but I'm not allowed to give you advice about your deadlines because that's in the
Mhm.
nature of advice which judges are prohibited from giving. So I can't tell you the answer to that, but I can generally say that the more quickly people do things, the better.
Gotcha.
So
We're
I'll say
going.
that.
We're going higher for sure. Thank you.
Okay, so here's the next step then that what will happen. Ms. Du Bois is going to be directed by the court to prepare the documents because she represents the plaintiff and the plaintiff is the prevailing party. Typically, we would ask the prevailing party to draft the documents. She will do that. She will send them to you, Mr. Way. She's going to send them to you by email. Ms. Du Bois, in your email, please indicate that you need them back by within 5 days. So Mr. Way, I'm going to give you 5 days to review the documents that she has sent to you. That should be enough time. You probably can do it sooner than that. I don't know what you may want to talk to somebody about. I just want to make sure you have enough time to think about it, review it, make changes or whatever. If you have changes to the document because you believe they are inaccurate, then redline the copies that she sends back to you and tell her, you don't want it to say this, you want it to say that, or whatever. So send her what you think that document should say if you disagree with what she puts in there, okay? Once you hear back from him, Ms. Du Bois, then send those documents in to Ms. Burks, and then she will send them to me. I will review them and I will sign the document that I think accurately reflects my ruling today, okay? And it should be a complete and final order, and be sure you include that language in it so that it's final and appealable and can go up to the next level. So, Mr. Way, she's only going to wait those 5 days. If she hasn't heard from you, then she's going to send that draft over to Ms. Burks, who will then send it to me.
I have not been able to communicate with Aaron not one time since the trial, or
It's
since
just by
any.
email. It's just by email.
She doesn't
You don't have to have a.
respond. I have not been able to communicate with her.
Yeah, she is being directed to draft the document. You are being directed to send her your changes if you have any. You may not have any because she may get it right and correctly reflect it. Now, let me say 2 things about that. One, if she doesn't hear from you within those 5 days, she's going to send it on. If she does hear from you within those 5 days, she's going to either make the changes you've requested because she's agreeing to them, or she's going to then send to Ms. Burks her draft and your draft. You are also welcome to send her draft and your draft directly to Ms. Burks. You can do that too, as long as you do it within those 5 days. So everybody can send whatever they want to Ms. Burks, who will then send it to me within that 5-day period after Ms. Du Bois drafts them and sends them to you. I'm going to direct her to get that to you by Monday of next week, March 4th. Okay, so it shouldn't take her too long. She's required. Can you get it to him by Monday?
Turner, I can get him to him in the next 5 minutes.
There you go. So no later than Monday, Ms. Du Bois is going to get it to you, and no
You
later
have
than
5
next
days,
week.
Aaron. Calm the hell down.
Excuse me. And then Mr. Way will have until Friday of next week to make his changes. Everybody by Friday of next week must send what they've received by then to Ms. Burks. Okay?
So then after that point, you're going to initiate your order, and that's going to come from you
After
then, right?
that point, I'm going to review what you have both submitted to each other. You're either going to submit an order that you both agree is correct, or you're going to say, I want this language, and the other one is going to say, no, I want that language. I am going to then review them both, and then I am going to sign the one that I think accurately reflects my ruling. And if you both get it wrong, I'll probably draft my own. But
Your Honor.
that seems unlikely.
I just want to clarify, the document coming from you, the judge, that's going to be the final document that I can appeal,
That's going to be the final order on the merits of the case that reflects what I've ruled today. That's correct.
Okay. And so when you initiate that.
Just to be clear, here are the deadlines. Ms. Du Bois has until Monday, close of business, to get the order to you. You will have until, I'm going to adjust that a little bit. I'm really going to give you 4 days because I want you to get it back to her by the end of Thursday of next week. So if you want to tell her you got changes to it, you have until the end of the day on Thursday to make those changes. I want by noon on Friday of next week for you all to send to Ms. Burks what you believe is a correct reflection of my ruling. Okay?
Okay.
I want that to Ms. Burks by noon so that she can then send it to me and I can look at it and get it back to you. I may or may not get it back to you that same day, depending on when I get it and what else I'm going on. You know, maybe a hearing that day. I don't know. But I want them to Ms. Burks by Friday of next week so that I can then review them and sign the one that I believe most accurately reflects my ruling. Now, Mr. Way, Ms. Du Bois, these orders, this order that we're talking about should include only those things that I'm ruling on and the request that I'm granting, the request that I'm denying, all that we've discussed today. Mr. Way, when you react to what she writes, that is not an opportunity to re-argue the things that we've talked about, right? It's just an opportunity to make sure that what she puts in that draft order accurately reflects what I've ruled, right? To the extent that you want me to reconsider the jury trial, I'm not doing that. That's order stands.
Yeah, we're going to escalate. Yeah.
That's fine. That's okay. I'm just saying that the purpose of this order is just to reflect what we're doing, not an opportunity to re-argue. You can re-argue that in another case, right? In another.
Gotcha.
This order just needs to say, here's what Livingston is ordering. And that way, when you go to the next level, that court can say, oh, here is what Livingston did. She got it right. She got it wrong. But here's what she did. And so this order needs to say what I did, not what you all think about what I did, right? Not whether you agree with it or disagree with it. Just is this what I actually ordered? And that's all that needs to be in that order, not your opinion about it. Just did I accurately say denied, granted, ordered, amount of money, amount of interest, attorney's fees, whatever, right? Speaking of attorney's fees, in addition to the $2,600 that's due on or before May 31, 2024, the appellate fees testified to in the event of appeal, those are granted as requested. And so that should be included in there as well. So again, we just need an order that says, okay, we had a hearing on February 29, 2024. Here is what Judge Livingston ordered. Yes, no, granted, denied, money, interest rate, so-and-so. That's what she did. And then I'm going to sign that. And then if anybody wants to appeal that, now the appellate court will know exactly what I did. And then they can decide, they can grade my paper, right? And decide whether I got it right or wrong, but at least they will know exactly what I ordered and what I did not order. Okay?
Your Honor.
In the meantime, I'm going to get 2 things because the writ of possession is going to issue immediately. You can send that over to Ms. Burks today. You don't have to wait for that for next week. You can send that today because your client is entitled to that today. Send that to Mr. Way and then send that to Ms. Burks today. Mr. Way, if you have objections to that.
I have objections to that.
No doubt about it, but send your objections to Ms. Burks as soon as you get that. And I will wait until later in the day to sign it, just to give you an opportunity to make whatever changes you think need to be made to it. But I will sign that one today.
As far as the eviction goes?
I will sign the order for immediate possession today because they're entitled to that. And then you have avenues that you can take related to what you want to do next about all that. But I want the order because they're entitled to it today. I want that one signed today. The other order can wait. Okay?
What about the property then?
You're asking me questions related to legal advice that I cannot give you. So I can't give you legal advice.
Okay, so I can appeal this, right?
Absolutely. Well, I believe that that's also a question about legal advice, but I think I've already said that my decisions are subject to being reviewed by a higher court. That court is called the Third Court of Appeals.
Okay,
Okay?
let me get on my
All right.
appeal then.
All right. Take care, everybody. It's nice to meet you all. Mr. Wade, don't forget on those other cases, you need to visit with the opposing side for
I
that.
can't,
And then
Judge
schedule
Livingston,
that.
I've
I
already
can't
talked.
hear you.
Hello?
Okay, I can hear you now.
Okay, I was just telling Mr. Wade to be sure to deal with, talk to Ms. Burks on those other cases. And I believe that concludes our time today. Thank you. Good luck to all of you.
Your Honor,
And
may
thank
we-
you, Ms. Duet, for taking it down for us as the court reporter. Thanks to Mr. LaRue for handling the Zoom call for us. Appreciate your assistance as well. You all have a great day, and we are adjourned. You may be excused.
I am certain there is more of this to come. I don't know what kind of video I just made. Like, my head is spinning from all of this. All I know is I'm in love with Judge Livingston. Yeah. Had a moment. She's amazing. If I could have like a tenth of her patience. Like, I don't even have words. Usually I have like something, I'm dying to say this one thing at the end. And with this, I'm like, huh? Your junk? Separate you from your junk? Like, what? What? Wait, how do you even get to that? I can't get from A to Z here. There's nothing in the middle. So, to be continued? Maybe? He's getting evicted, so we'll see. Put it on my calendar. I got a new calendar. I'll put it on my calendar. I even gave my cat catnip to try and get him to like be all crazy and stuff for you. I think it passed him out. I think he overdid it. He smoked a little too much kitty weed. What can you do? Have a great day. See you again soon.